Gachagua in petition number Kirinyaga, Kirugoya, I believe it's Kirugoya, 5015 for the petitions.
Mr. Kibe, we consolidated and we came up with a new lineup of the parties. So it may not be very appropriate to keep on referring to.
I did take the notes, sir, but I mean some of it. The person who took the notes is not here.
That's okay. We will supply. We'll supply.
I have not seen any order to indicate now that.
Okay. We will supply after the proceedings of the day.
My lords, your leadership, form waiting. I appear with Mr. Soanya, George Sekimpa, and Tom Macharia for the Deputy President of the Republic of Kenya in the consolidated petition and in any other petition where he is a party. Thank you.
My name is Khalid. I appear for Procedural. I think the party in C565 is my line friend with his son. I haven't seen him. And then I also appear for myself.
My lady and my lords, for the third petition, my name is Rudy. May it please you, my lady and my lords, my name is Nelson Harvey. I appear for the Interested Party Legal Society of Kenya, together with my two colleagues, Jose Manuel.
Where are they? Mr. Jose and who?
Jose Manuel and Kevin Muju.
Where's Kevin?
Behind the
Maybe perhaps for guidance on which matters we are taking quorum on. Because this afternoon, and I believe when we will address it, we were served with a notice from the office of the deputy registrar indicating that there were several matters that were mentioned before this morning, this afternoon. And last evening when you were breaking, we were to come for a ruling. Perhaps we need to have clarity that we do not have answer of those.
We are dealing with the ruling matter in which the ruling is supposed to be delivered now. After that, we'll give directions.
The nature that is there for them, to me, there are some advocates who have gotten on record for quorum to participate, or they are not participating.
Like who?
Like Nelson Harvey. But is there any other concern before we read the ruling? Our ruling is ready on the consolidated petitions with the lead file being petition number E565. We have set out the structure of the ruling, but we'll begin from our analysis of the issues that we think are relevant for now. This is the ruling. Having carefully considered the pleadings, submissions, and evidence on record, we consider the following issues arising for determination. One, what are the prevailing constitutional and statutory interpretation methods? Two, whether the Honorable the DCJ can assign judges pursuant to Article 165, sub-Article 4 of the Constitution. Three, other related matters. On the first issue, the Constitution is a document sui generis. It is the norm which legally commands superiority and dominance over any other laws, and its interpretation, as of necessity, must be in a manner that all other laws bow to. The court in S versus Atchison, 1991, captured the centrality of the Constitution as follows. The Constitution of a nation is not simply a statute which mechanically defines the structure of government and the relationship between the government and the governed. It is a mirror reflecting the national soul, the identification of ideals and aspirations of a nation, the articulation of the values bonding its people and disciplining its government. The spirit and tenor of the Constitution must therefore preside and permeate the process of judicial interpretation and judicial discretion. In the matter before the court, the High Court has once again been called upon to address the issue as to whether the Honorable the Deputy Chief Justice of the Republic of Kenya, whom we refer to herein as the DCJ, can exercise the power of assigning and empaneling expanded benches of the High Court. As such, the interlink between Articles 161 sub-Article 2 and Article 163 sub-Article 1 and Article 165 sub-Article 4 of the Constitution, as well as Section 5 of the Judicial Service Act, come into play. On that score, it is paramount to briefly look at how the Constitution and the statutes ought to be interpreted. As a starting point, the Constitution itself provides for its own theory of interpretation. That is in Article 20, sub-Article 4, and Article 259, sub-Article 1. Article 20, sub-Article 4, requires courts, while interpreting the Bill of Rights, to promote the values that underlie an open and democratic society based on human dignity, equality, equity, and freedom, and the spirit, purport, and the objects of the Bill of Rights. Article 259, sub-Article 1, commands courts to interpret the Constitution in a manner that promotes its purposes, values, principles, advances, and rule of law, human rights and fundamental freedoms in the Bill of Rights, permits the development of the law, and contributes to good governance. In hailing the Constitution of Kenya as a highly transformative one, courts have over time developed various methods or canons of interpretation. In the case of David D. and others versus Attorney General, the learned High Court judges dealt with 4 constitutional interpretive principles, being that the Constitution must be interpreted holistically, that the Constitution does not favor formalistic approaches to its interpretation, and it must not be interpreted as one would a mere statute. The Constitution has provided its own theory of interpretation to protect and preserve its values, objects, and purposes, and that in interpreting the Constitution, non-legal considerations are important to give its true meaning and values. The Supreme Court, in the matter of the Kenya National Commission on Human Rights, Supreme Court advisory opinion reference, which I've given at paragraph 26, answered the question as to what holistic interpretation of the Constitution means. The court stated as follows: but what is meant by holistic interpretation of the Constitution? It must mean interpreting the Constitution in context. It is contextual analysis of a constitutional provision, reading it alongside and against other provisions, so as to maintain a rational explication of what the Constitution must be taken to mean in the light of the history of the issues in dispute and of the prevailing circumstances. In the case of Tiny Fuza versus Attorney General, which I've given, citation I've given, the court was of the firm position that the Constitution must be read as an integrated whole. The court observed as follows: the entire Constitution has to be read as an integrated whole, and no one particular provision destroying the other, but each sustaining the other. This is the rule of harmony, the rule of completeness and exhaustiveness, and the rule of paramountcy of the written Constitution. On the tenet that the Constitution does not favor formalistic approaches to its interpretation, and that it must not be interpreted as one would a mere statute, the Supreme Court pronounced itself in the case in interim independent electoral commission. The court said as follows: the rules of constitutional interpretation do not favor formalistic or positivistic approaches. The Constitution has incorporated non-legal considerations which we must take into account in exercising our jurisdiction. The Constitution has a most modern Bill of Rights that envisions a human rights-based and social justice-oriented state and society. The values and principles articulated in the preamble, in Article 10, in Chapter 6, and in various provisions reflect historical, economic, social, cultural, and political realities and aspirations that are critical in building a robust, patriotic, and indigenous jurisprudence for Kenya. Article 159, sub-article 1 states that judicial authority is derived from the people. That authority must be reflected in the decisions made by the courts. Close quote. In expounding the principle that the Constitution has provided its own theory of interpretation to protect and preserve its values, objects, and purposes, the retired Chief Justice, His Lordship, Honorable Mutunga, had the following to say in his concurring opinion in the Speaker of the Senate and another versus Attorney General. The Honorable Chief Justice then had this to say: in both my respective dissenting and concurring opinions in the matter of principle of gender representation in the National Assembly and Senate, I argued that both the Constitution 2010 and the Supreme Court Act 2011 both provide comprehensive interpretive frameworks upon which fundamental hooks, pillars, and solid foundations for the interpretation of our Constitution shall be based. In both opinions, I provided the interpretive coordinates that should guide our jurisprudential journey as we identify the core provisions of our Constitution, understand its content, and determine its intended effect. He proceeded to say more, which I have included, but I will not read. The Supreme Court also expounded the incorporation of non-legal considerations and their importance in constitutional interpretation. In the case Communications Commission of Kenya and 5 others versus Royal Media Services, at paragraph 356, the court said this: we revisit once again the critical theory of constitutional interpretation and relate it to the emerging human rights jurisprudence based on Chapter 4, the Bill of Rights of our Constitution. The fundamental right in question in this case is the freedom and the independence of the media. We have taken this opportunity to illustrate how historical, economic, social, cultural, and political content is fundamentally critical in discerning the various provisions of the Constitution that pronounce on its theory of interpretation. A brief narrative of the historical, economic, social, cultural, and political backgrounds to Articles 4, Sub-Article 2, Article 33, Article 34, and Article 35 of the Constitution has been given above in paragraphs 145 and 146. We begin with the concurring opinion of the CJ and the President in Gitirau Munya case, where there was references to Black Law Dictionary, where it was said that references to Black Law Dictionary will not, therefore, always be enough, and references to foreign cases will have to take into account these peculiar Kenyan needs and context. It is possible to set out the ingredients of the theory of the interpretation of the Constitution. The theory is derived from the Constitution through conceptions that my dissenting and concurring opinions have signaled as examples of interpretive coordinates. I'll not read the entire quotation. Then in the case of Center for Rights, Education and Awareness and another, the Court of Appeal also dealt with the subject of constitutional interpretation and laid out the very principles discussed above. The court further recounted the nexus between the principles of constitutional interpretation and the principle of statutory interpretation in the following manner. The principles on constitutional interpretation are not new. They also apply to the construction of statutes. There are other important principles which apply to the constructions of statutes, which, in my view, also apply to the construction of a constitution, such as presumption against absurdity, meaning that a court should avoid a construction that produces an absurd result, the presumption against unworkable or impracticable result, meaning that a court should find against a construction which produces unworkable or impracticable result, presumption against an anomalous or illogical result, meaning that a court should find against a construction that creates an anomaly or otherwise produces an irrational or illogical result, and the presumption against artificial result, meaning that a court should find against a construction that produces artificial result, and lastly, the principle that the law should serve public interest, meaning that the court should strive to avoid adopting a construction which is in any way adverse to public interest, economic, social, and political or otherwise. The court, as an independent arbiter of the Constitution, has fidelity to the Constitution and has to be guided by the letter and spirit of the Constitution. On our part, we wish to re-emphasize that the Constitution directs that it shall be interpreted in line with the doctrine of living constitutionalism. The doctrine holds that a constitution is a living document meant to evolve over time to reflect societal changes, contemporary realities, and shifting values. It further recognizes that the law is dynamic and adaptable to evolving circumstances, often encapsulated in the maxim that, in quote, the law is always speaking. It underscores the constitutional provisions as not static or frozen in time, but must be understood as applying to current circumstances regardless of their original context. This interpretive approach ensures that the Constitution remains relevant and effective in guiding the governance and legal framework of a modern, dynamic society. Moreover, the doctrine that the law is always speaking aligns with the purposive approach to constitutional interpretation as endorsed by courts in various jurisdictions. Under this approach, courts are required to interpret constitutional provisions in a way that gives effect to their underlying purpose and objectives, rather than adhering to a rigid or literal reading. Further, courts have emphasized the need for a flexible and forward-looking interpretation of the Constitution to meet the needs of a modern state. With the above interpretive principles in mind, we will now deal with other issues posed in the application under consideration.
I will deal with the second issue on whether the DCJ can assign judges pursuant to Article 165, Sub-Article 4 of the Constitution. There is no doubt that this was the most contested issue in the subject application. Article 165, Sub-Article 3 and Sub-Article 4 of the Constitution provide for empanelment of benches of an even number of judges as follows. Permit me not to go through that. In dealing with the above issue, courts have taken two diametrically opposite positions. One of them being that the assignment of judges is a constitutional duty which can only be undertaken by the Honorable Chief Justice. As such, the Honorable DCJ cannot assign judges under Article 165, Sub-Article 4 of the Constitution. The other position posits that although the duty to assign judges is provided for in the Constitution, its implementation is administrative, and that duty can be undertaken by the Honorable DCJ. In Kenya Medical Research Institute versus AG, which was a three-judge bench of this court, held as follows, the quote, paragraph 37. Therefore, by empaneling this bench, the Chief Justice was carrying out his constitutional mandate as opposed to similar functions under the former Constitution, which were hinged on the constitutional provisions and were merely administrative, end of quote. In Lena, Conchella, and others, which was a five-judge bench of this court, the court went ahead and described the role of the Chief Justice under Article 165.4 as constitutional as opposed to a merely administrative function. It also said it is our view that a constitutional mandate of the CJ can be judicial, administrative, or political, and the current Constitution does not indeed state that the Chief Justice is the head of the judiciary which embodies all these functions. The learned judges in that empaneled bench then found that the constitutional mandate exercised by the CJ under 165.4 of the Constitution is an administrative function. The court also elaborately dealt with the issue as to whether such an administrative function could be undertaken by the Honorable DCJ, and in the end, the court rendered itself as follows. I quote paragraph 78. It therefore our finding that constitutional function of the CJ to assign benches under Article 165.4 being an administrative function can be performed by the Deputy Chief Justice when the Chief Justice is for good reason and unable to perform. End of quote. The petitioners in these matters also cited the decision in Okoiti versus JSC and another, which is Constitutional Petition number A408 of 2020, as addressing the position that the assignment of judges is a constitutional mandate and the sole preserve of the Honorable Chief Justice. The decision was delivered by yours truly, who is part of this expanded bench. We have carefully considered the said decision. One of the issues therein, which may be said to have a bearing on this matter, was whether the Honorable CJ could rely on Section 5, subsection 4 and subsection 5 of the Judicial Service Act to authorize the Honorable DCJ to serve as the acting Chief Justice when the Chief Justice was proceeding on leave pending retirement until when a succeeding Chief Justice was appointed. As the matter did not deal with the nitty-gritties of the aspect of assigning of judges, but rather the constitutionality of the actions of the CJ who was exiting service, we respectively find that the issue is not at par with what is under consideration in this instant application. The said decision is hence distinguishable. Returning to the matter at hand, it is imperative to look at the various terms which come to play in this matter, including the administrative actions as well as judicial actions. I we have gone through that. I do not think there's need for me to read all that. It's in the ruling, and I proceed to state that from the above discourse, we do not find any difficulty in affirming the position that a constitutional mandate of the Honorable Chief Justice can be judicial, administrative, or political. We further find and hold that the constitutional mandate exercised by the Honorable Chief Justice under Article 165, Sub-Article 4 of the Constitution is a constitutionally administrative function. We shall now consider whether the function of the Honorable Chief Justice under 165, Sub-Article 4 of the Constitution can be performed by the Honorable DCJ. Article 161 of the Constitution establishes the office of the Chief Justice as the head of the judiciary, and that of the Deputy Chief Justice as the deputy head of the judiciary. Article 163 of the Constitution creates the Supreme Court and designates the Honorable Chief Justice as the president of the court. The Deputy Chief Justice is to deputize the Chief Justice and is also the vice president of the court. Article 171 of the Constitution establishes the Judicial Service Commission, or the JC, as one of the Chapter 15 commissions. The Honorable Chief Justice in JC is the chairperson, and in this scenario, and unlike the constitutional architecture in Articles 161 and 163, the Honorable DCJ is not the vice chairperson of JSC. Running alongside the foregoing are the functions of the Chief Justice and the Honorable DCJ as provided for in Section 5 of the Judicial Service Act. The provision states as follows. This is in respect to administration of the judiciary. I do not read through all that. I proceed to say that the decision in Lena Conchela also dealt with the definitions and various types of deputies, and ultimately rendered itself in the following manner. I think this one I should quote. Paragraph 77, it says, it has been canvassed before us that where the Constitution intends the Deputy Chief Justice to act on behalf of the Chief Justice, it has expressly stated so. Specific examples cited were Articles 141.1, 144.4, 148.4. These provisions fall under Chapter 9 of the Constitution that deals with executive. This chapter does not have a general provision as regards the deputization of the Chief Justice by the Deputy Chief Justice, as is provided for in Article 161 to be in Chapter 10 of the Constitution on the judiciary. Hence, the provision of the deputization of the Chief Justice in Chapter number 9. A holistic and purposeful interpretation of Article 161 2B of the Constitution and Section 5 of the Judicial Service Act leads us to the conclusion that the Deputy Chief Justice substitutes the Chief Justice where necessary. End of quote. In the end, the learned judges found and held that the constitutional function of the Honorable Chief Justice to assign the benches under Article 165 for the Constitution, being an administrative function, can be performed by the DCJ when the DCJ is for good reason unable to perform this function. On our part, we have carefully addressed our minds to the issue. We find that there was a deliberate scheme by the drafters of the Constitution for the Honorable DCJ to deputize the Honorable CJ as Deputy Head of the Judiciary and as the Vice President of the Supreme Court, but not in the JSC. Such was an emphasis on the various manifestations of the constitutional duties bestowed upon the Honorable Chief Justice and the Honorable DCJ. As such, the prevailing legal position is that the Honorable DCJ can deputize the Honorable CJ in discharging judicial functions and in the administration of the judiciary as an arm of government, but cannot do so in respect of the affairs of the JSC. Our attention has also been drawn to the provisions of Article 259, sub-Article 3B of the Constitution, which states as follows. This refers to construing the Constitution, and sub-Article 3 provides as follows. Every provision of this Constitution shall be construed according to the doctrine of interpretation that the law is always speaking, and therefore, among other things, B, any reference in this Constitution to a state or other public or public office or officer or a person holding such an office includes a reference to the person acting in or otherwise performing the functions of the office at any particular time. Emphasis, or otherwise performing the functions of the office at any particular time. The above provision creates three tiers in which constitutional functions can be exercised. That is, by the substantive office holder, or by a person in an acting capacity, or by a person otherwise performing the functions of the office at any particular time. In our understanding, and against the background of the doctrine as stated, the drafters of our Constitution were deliberate about ensuring that the administration of duties and the application of the constitutional provisions are continuous and seamless, recognizing the necessity for offices and their functions to be performed even in transitional or extraordinary circumstances. Such an interpretation avoids technicalities and vacuums that could disrupt the functioning of said officers of public institutions, thereby promoting administrative efficiency and upholding the principles of constitutional governance. The provision reflects the broader principles of the rule of law and good governance, which require that state and public officers continue to function effectively, even during periods of transition or when the substantive office holder is unavailable. It in turn promotes legal certainty and administrative efficiency by ensuring that all constitutional responsibilities are carried out without distraction. For this reason, the functions of Article 165, sub-Article 4, in our view, and in as far as the same relate to the office of the Chief Justice, also includes the Deputy Chief Justice acting in the capacity of the office of the Chief Justice or discharging its functions in an interim, acting or auxiliary role. At this point in time, we also wish to point out that the Honorable Chief Justice empaneled this very bench on the 14th day of October 2024 to deal with 6 constitutional petitions that inter alia challenged the first petitioner's impeachment process in the National Assembly. The said petitions are still current. On the 18th of October 2024, the Honorable DCJ empaneled the same bench to deal with constitutional petitions challenging the impeachment of the first petitioner in the Senate. To us, it is beyond peradventure that the Honorable DCJ can assign judges under Article 165 sub-article of the Constitution whenever he or she is discharging any of the constitutional functions on behalf of the Chief Justice. In this case, we do not find any fault in the Honorable DCJ assigning judges to sit in this bench, more so when the Honorable Chief Justice has not raised any red flag.
Right. I will deal with a question of other related issues that came up during the submissions on the application. Besides the issue of the benches and panelmen by the Deputy CJ, several additional issues have been raised. The bench found it necessary to address these issues so as to ensure both the completeness of the record and finality in the issues raised. During the submissions, an issue was raised concerning the directions issued by the 3-judge bench and the transmission of the files in Nairobi Petition E565 of 2024, Kerugoya petitions E013 and E014 consolidated, as well as E015 of 2024. A review of the CTS, that is a case tracking system, confirms that the petition in E565 of 2024 was filed on the 18th of October 2024 at 8:00 a.m. Later that same day, approximately 5 hours on at 1:51 p.m., Justice Chacha Muita dealt with an application filed under certificate of urgency which had been submitted alongside the petition. By 5:33 p.m., roughly 3 hours after the earlier application, a notice of motion application dated the 1st of October 2024, it was dated the 1st of October 2024, was filed, this time by the respondents seeking the following orders. 1, that the application be certified as urgent and service of the application be dispensed with in the first instance. 2, that pending the hearing and determination of that application, inter partes, this honorable court be pleased to set aside, vary, or review the orders issued on the 18th day of October 2024, that is the interim conservatory orders. 3, that in the alternative, this court be pleased to set aside, vary, or discharge the ex parte orders issued on the 18th day of October 2024, and 4, that this honorable court do issue any other orders it deems fit in the interest of justice. Following its empanelment on the 18th of October 2024, and having received directions from the Office of the Deputy CJ, the bench deliberated on the appropriate directions to be issued. On the 19th of October 2024, at 12:20 p.m., the bench issued the following directions. That in light of the urgency of the matter and the weighty issues raised therein, we direct that the application be served and responded to forthwith for hearing inter partes on Tuesday, the 22nd of October 2024 at 11 a.m. in open court number 18. Petition E013, on the other hand, was filed on the 25th of September 2024 at 8:33 p.m., while petition E014 was filed on the 2nd of October 2024 at 7:07 p.m., both way past official working hours of the court. The CTS will further show that an application in E014 was filed on the 30th of September 2024, and directions were issued on the very same day, although the matter was not certified as urgent. Subsequent directions and a ruling issued on the 11th of October 2024 resulted in the consolidation of petitions E013 and E014, followed by an order for empanelment. As the record on CTS will further show, the directions issued by the court in E014 of 2024, which were issued on the 2nd of October 2024, were again issued at 6:22 p.m., which is outside of what one would call the routine working hours of the court. This was due to the urgency demonstrated in the application, which sought directions regarding the then ongoing public participation process. The bench takes great exception to the petitioner applicant's conduct that when favorable to them, issues of orders, rather orders issued outside of what one would refer to as the normal working hours of the court raise no concern. However, when the court acts in an instance where it has been moved by any other party and likewise proceeds to deal with an application at hand, the applicants show their indignation. Moving to petition E015, The CTS again would show that the same was filed on the 18th of October 2024. And once again, following the directions issued by the court, this bench was empaneled on the 18th of October 2024 to hear all the three petitions, that is E565 of 2024, E013, E014, and E015, all of 2024. From this sequence of events, it is notable that the interaction between counsel and the courts on an almost real-time basis is not novel, and is in fact a practice that counsels are well familiar with. The CTS enables both counsel and the court to operate in real time, transcending traditional time limitations. This fact also buttresses the argument that with the advent of the CTS system, it is not unusual for courts to issue directions within the filing of an application or outside of what once again would be referred to outside the routine work hours of the court where circumstances do so require. Moreover, in raising the issue of improper seating, the applicants omitted a crucial fact, which was that the court had been moved by the respondents in petitions E565 of 2024 and E015 of 2024. As such, the court did not convene suo motu, but rather in response to the applications before it. The applicants have repeatedly referred to this convening as a sitting of the court, a term that we feel as a bench requires clarification and demystification. It is a matter of judicial notice that since the onset of the COVID-19 pandemic and the introduction of the case tracking system, the tradition of dealing with certificates of urgency has since evolved. Allow me to quote the practice direction number 19A of the High Court Practice Directions of the 11th of January 2022, which states as follows, that applications filed under certificate of urgency shall be considered by the judge, we emphasize here, at the earliest opportunity. While the practice directions also stipulated that applications filed after 12 p.m. may be considered the next working day, the full adoption of the e-filing system across the judiciary has largely rendered this provision obsolete. Applications are now processed almost in real time, a fact well known to the justice users across the country and which we have demonstrated in this ruling. Furthermore, Practice Direction 19B confers discretion upon the court to issue orders or directions without the attendance of advocates or parties. This implies that the court can indeed issue directions on an application without the need for a formal sitting. The relevant provision, once again, reads as follows: that the court may, in its discretion, issue orders stroke directions without the attendance of the advocates or parties. I end quote. In this court, rather in this case, the issue has been raised that this court allegedly sat and considered an application by the respondent on a Saturday outside of the official court hours. The ordinary definition of a sitting, as provided in the Black's Law Dictionary, is a formal occasion when the court convenes to conduct its business. In this instance, no such formal sitting occurred. In this instance, may I repeat, no such formal sitting occurred. Rather, the bench merely conferred and issued directions electronically as expressly permitted under Practice Directions 19B. This is markedly different from a court session in which the bench is convened to hear and determine a matter. Furthermore, no evidence or proceedings have been presented before this bench to support the claim that a formal sitting did take place. Accordingly, it is only fair and reasonable for the parties to dispel any notion that this bench convened to hear arguments from any party ex parte before issuing directions. No such formal sitting took place, the court again emphasizes, and directions were issued electronically in line with established practice and procedural rules. We do, however, recommend that the current practice directions and relevant statutes, such as the High Court Organization and Administration Act, be amended so as to provide a much needed further clarity on this subject. Moreover, for the avoidance of doubts, and out of all the prayers sought by the respondent, only prayer number 1, which sought to have the matter certified as urgent, was granted. No other reliefs were considered or granted at the time. It is evident that the court was fully cognizant of both the urgency of the matter and the potential repercussions that granting any further ex parte orders could have had on the prevailing status quo. With this understanding, and in an effort to balance the scales of justice, the bench issued the directions that are now being challenged. We hold the view that there was nothing unconventional in the manner in which this bench dealt with the 2 applications filed under certificate of urgency. As regards the arguments that directions had already been issued by the respective courts for a mention before the bench on the 24th of October 2024, the arguments by the applicants appear to insinuate that the bench ought to have retained the date. For clarity purposes, this date had not been given by this bench, rather this date had been given prior to the empanelment of this bench. However, upon empanelment of the bench, the applications under certificates of urgency, the ones that I have just referred to, were filed, which applications were dealt with, and we feel rightly so. Being seized of the matter, it is our view that the bench retains the discretion to issue appropriate directions depending on the developments and in light of its mandate, as it did, having been moved by a party under certificate of urgency. With respect to the claim that was raised on discriminatory transmission of files to the bench, it must be emphasized that this bench has no role and no control whatsoever in the administrative processes that occur prior to its empanelment. Concerns have been raised about delays in the transmission of certain files, but it is crucial for us to clarify that the term transmission in this case may not necessarily refer to the physical transfer of documents. In the context of judicial processes, particularly with the advent of digital systems, transmission may very well refer to the electronic movement or assignment of case files within the judiciary's digital infrastructure. We say this on the strength of the fact that with the CTS, all filed documents are available in real time across the judiciary, eliminating the need for physical file movement. Let me refer once again to practice direction number 41A Roman 2, which provides that advocates and litigants shall have access to court information electronically. While this court cannot and will not speculate on the causes of any delays in file transmission, The bench nonetheless finds no basis for concluding that such delays amount to any form of procedural omission on the part of the bench, as no such evidence has been presented. The applicants have equally in their submissions attempted to cast aspersions on the proceedings of this court, some of which I have already referenced. That is that the court was convened on a Saturday, stating that there is no urgency in this matter, and so there was no need to convene the sittings of the 22nd day of October 2024, that this matter is being given priority over other petitions which have been filed, an insinuation that the bench is part of a conspiracy to infringe the petitioner's Article 50 right to fair hearing, and what I have again alluded to, that the transmission of the files from the Kiruhoya High Court took place with what has been referred to as supersonic speed. One of the counsels went further by intimating that an exercise akin to the radical surgery may well be forthcoming, a statement which the bench, with tremendous respect, perceives as a veiled attempt at intimidation. The bench feels that such remarks are regrettable and wholly inappropriate. This bench remains firm in its duty and will not be swayed or influenced by any form of intimidation, regardless of its source. The bench takes the view that the applicants appear to selectively focus on aspects that favor their position while conveniently disregarding that the clients that the applicants are presently benefiting from final conservatory orders, which this bench did not deem it fit to lift. Despite having obtained final conservatory orders, as the court has already observed, it is now apparent that the applicants no longer perceive the urgency in this matter. Instead, they seek to cast aspersions on this court for addressing the matter with the necessary expedition. Such conduct is contradictory and undermines the very urgency that the applicants had initially invoked. The bench notes that the issues raised in this petitions have on various occasions and before different judges consistently been certified as urgent and as involving substantive constitutional questions. This underscores the gravity and significance of the matters at hand. One of the counsels again insinuated that this bench is part of a conspiracy to violate the petitioner's right to a fair hearing under Article 50 of the Constitution. The bench finds that these submissions are without any foundation and wholly without merit. This court has not issued any rulings or directions that would suggest such an intention. It is apparent that this argument was made for the sake of the gallery, and we find it unnecessary to therefore address it further, safe to reaffirm that this court remains fully committed to upholding the Constitution and the rule of law. In conclusion, we do find and hold that the accusations made by the applicants against this bench are entirely without merit. On this link, the last part of the link is whether the matter raises issues of public interest which require expeditious disposition of the petitions. The applicants have urged that the applications before the court are not urgent and have loudly wondered why it was necessary to give directions for hearing of the applications on the 22nd day of October 2024. In response, the bench quotes Article 131, which establishes the office of the president and the office of the deputy president. And also we have cited Article 147 with regards to the functions of the deputy president, just to lay context. And the context is this, according to the bench, that the first petitioner has been impeached under Article 145 of the Constitution, marking the first instance of such an event in Kenya's history. The impeachment of the said petitioner has undoubtedly garnered significant public interest, and these court proceedings represent a direct challenge to that impeachment. It goes without saying that these legal proceedings are of paramount concern to the citizens of this country. To suggest, as the applicants have, that this matter lacks urgency and does not warrant prompt adjudication is disingenuous and dismissive of its far-reaching implications. We have taken the liberty to define the term public interest in the Black's Law Dictionary, and you will also find the Supreme Court of Kenya's definition of public interest in the case of Steele versus Roscoe, which permit me not to get into. Safe to say that from the foregoing, a matter is of public interest if the holding on law affects a considerable number of people in society, if the holding in law involves government and or government agencies, if a determination of law affects the proper functioning of public institutions of governance or of the court's scope for dispensing redress, and if the holding of law affects the mode of discharge of duty by public officers. These proceedings, in our view, as the bench, raise enormous public interest, and it is in the interest of that public that these proceedings are heard and finalized most expeditiously. Therefore, the aspersions cast by the applicants concerning the directions for the hearing of the applications before the court on the 22nd day of October 2024, in our view, lack basis, and they are dismissed. Thank you.
This position, having carefully considered the application, we are satisfied that the prayers sought herein must fail. Nonetheless, as indicated in our ruling, there is a pressing need for a clear practice directions regarding the procedure and the process for handling virtual and online directions and proceedings. We commend the applicants as this application has illuminated the necessity for such guidelines and made the issue more apparent. As such, we hereby direct the Honorable Deputy Registrar of this division to transmit a copy of this ruling to the Honorable Chief Justice. Before we conclude, the bench wishes to once again emphasize its unwavering commitment to objective neutrality in this matter. We assure all parties that their right to a fair hearing remains fully safeguarded. The bench, acting in fidelity to its oath of office and in strict adherence to the dictates of the Constitution, remains resolutely committed to the fair and just determination of the issues before it. Finally, the application dated 22nd of October 2024 is disallowed with costs in the course. Leave to appeal is hereby granted. Certified copies of these proceedings and rulings shall be availed upon payment of the requisite court fees as the case may be. That's the ruling of the court.
Well, on behalf of the petitioners, we have listened to the ruling. We have got no problem with the feasibility of it one way or the other. We leave it to our clients, the decision of whether or not they will appeal the ruling, largely because of a number of instances where words have been put into the mouths of the petitioners that were never uttered. That as it may, I believe since we received some communications from the Deputy Registrar and there were certain other pending matters in the files that were under consideration. We shall await the directions of the court before, from the petitioner's point of view, we can say one or two things. I do not know whether, at least since as my landlord senior, on the committee has anything to add.
My lords, Your Ladyship, we appreciate that this honorable court of its own volition has granted leave to appeal. Speaking for myself, obviously, the decision is that of the client. So I will be advising the client, but it is for the client to make the final decision. But in fairness to me as counsel, another counsel on this bench, I will certainly be seeking to persuade my client to appeal. One issue of accusing counsel to have been talking to the gallery, that is not something that should be left on the record of this court. It is damaging to counsel, and that is an issue that definitely needs to be taken out of the record of this court by the court of appeal. It was a very unfair position.
May it please the court, on behalf of the respondents, we thank you for the timely nature of the delivery of that ruling to allow this matter to proceed. We note that you have permitted the parties leave to appeal, and we support that. The respondents support a fair resolution of this dispute in accordance with the law, and therefore we would not oppose their right to appeal. Having said that, however, and in reference to my learned friend, Mr. Kipe Mungai, who has alluded to other petitions pending before court, it is the respondent's position that we should exhaust all matters today relating to the matter that has been called out by your clerk or your legal assistant. I apologize to the lady, so that we may exhaust that, after which the court will give directions on any other matter that may be before you or may be anticipated to come before you. We thank you.
My lord, my lady, on behalf of the National Assembly, I wish to express our gratitude for the very clear ruling that the court has delivered this afternoon. The ruling has dealt conclusively, not just with the matters that were contained in the application that was hurriedly filed and responded to yesterday afternoon, but indeed some of the other peripheral issues that the petitioners unfortunately took a lot of court time yesterday to deal with. My lords, my lady, the National Assembly has filed an application dated the 18th of October 2024. And I believe that application was referred to in the ruling a few moments ago. That application, subsequent to the ruling that you have just delivered, I submit is the next issue that the court should deal with. And just to put it on record, my lord, that we are ready to proceed with that application this afternoon. Members of the court will recall that last week on Tuesday, on the 15th of this month, at an hour not very different to this, when it suited the petitioners to have their application for conservatory orders heard, they insisted on it being heard. And we request that the urgency in this matter remaining and having been noted by the court, we proceed with the hearing of that application, which has been fully responded to, immediately after this. I'm most obliged.
My lords and your ladyship, further to that, for Senate, I wish to state, my lords and your ladyship, that unlike the petitioners, we are willing to argue the application in a record 30 minutes.
Is this the same application?
Yes, the application dated 18th October 2024. We will only ask for 30 minutes to exhaust our application. We will dive straight into constitutional principles. We will not take much time. The respondents can have as much time as they want so that this matter can be concluded. My lords, Mr. Kibe has talked about the gallery of Paul Multe Senior Counsel. From that side, it was apparent that they were not just addressing the court. They were addressing other matters.
Do we need to
let us not go into that.
Do we need to engage in arguments on that?
Let us not go into that now.
I will withdraw that.
Yes.
We are ready to proceed.
No, we don't want you to raise something and then you say you withdraw it. You know, after causing the damage, we withdraw properly.
I will withdraw the remark that the petitioners are addressing the public gallery today.
My lords, my lords, with your permission, my lady, yesterday we were barred from being part of this proceedings. We have seen communication that we are now legally here. We have stopped mourning. Could we be allowed officially by these files being called so that we are together? We still feel that we are excluded when we are before you.
In which petition? In which petition?
There is petition 5E570,
Okay.
E550, E541, E572 that are supposed to be withdrawn. That
Yes.
we complained to the CJ in the morning, and the CJ has directed we appear here and be part of this genocide. Kindly let us be part of it.
Your Lordship, equally, I rise as the advocate appearing in E509 and associate myself with the submissions made by my learned senior counsel, Paul Multe, and the ones made by my learned friend, Senior Kibe. Your Lordship, to the best of our knowledge, in the matter E015, when we broke yesterday, there was a promise by the court, and the court has kept that promise, that we shall be coming for a ruling of the application that was made. Yesterday, I indicated to the court, Your Lordship, that this court was constituted to deal with the consolidated petitions E522 consolidated, and now E565 consolidated. And we have been issued the notice that my learned friend Mr. Omari is referring to, that he also seized of 4 other matters: E570, E550, E541, and E572. Your Lordship, the notice that was issued to us indicated that we are coming for a mention in respect to those particular files. I hope the court is in possession of this notice, so that the court may refer to the same. Subsequent to which, Your Lordship, will be seeking your guidance on how we deal with the applications filed therein. For example, pursuant to my client's instructions, we filed an application dated the 22nd of October for the recusal of the bench. We wish that subsequent to the court addressing and acknowledging that the other files before it, that I get directions on how to dispose of my application, for which, Your Lordship, the application was served. I wish to take directions exclusively and specifically on that particular matter.
My lords, may it please you, I hate to interrupt, but this is most unprocedural. we are all counsel of some reasonable experience. We all appreciate, some of them here are very senior advocates, very senior counsel. The file before the court is the only file in which you can make an application. The court cannot make orders in files that are not before it. All these files physically brought to the court are not before court. They will be before court when they are called out by your legal assistant as being available for the court to make orders. We therefore object to this manner of conducting these proceedings. It is our very humble submission that it is yet another attempt to delay the expeditious disposal of this matter.
Your Lordship, very
My Lord,
briefly. Very
if I may.
briefly.
If I may, my Lord.
Yes.
There are matters that you have certified as urgent and that you have identified as being urgent. And I say this with a very heavy heart. My learned colleagues for the petitioners have been engaging in this dilatory tactic since yesterday. There are 2 applications before you that are certified as urgent. There are several other matters that have applications that perhaps have not been certified as urgent. Perhaps your lordships may be kind enough to deal with those urgent applications, and these matters can be dealt with later on. The files may be here, but they're not before the court.
Your Lordship.
Okay, you have talked enough.
Council on this side we have,
Yes,
council on that side appears to be taking the whole of it.
because they stand
Please,
much.
please.
Just speak, Mr. Mute. If you want to be heard, just speak. We'll
My
listen to
lord,
you.
I'm asking
Yes.
for equity of power.
We-
Afford time to council on this side.
They stand and speak. You also just stand and speak. We have not stopped you. Stand. Yes, speak.
My Lord, I think for purposes of clarity, yesterday, when we started hearing on the issue of validity of the bench, which has now been disposed by the ruling in red, the question that we wanted was the application for the validity plus the issue to do with the recusal we had together. The understanding of the court and ourselves was that they cannot be dealt with together. So that the second preliminary issues after the issue of the validity of the bench has been disposed of are the 3 pending, I think, actually, I know I'm talking about 3 applications for recusal. Those are preliminary issues and they relate to the same consolidated matters that this court has given a ruling on. That is issue number 1. Issue number 2, my lord, that is important to be noted. Yes, the consolidated file that is before you has that applications for recusal. That's what my learned colleague is emphasizing. So the second business of the court was supposed to be that one. But more importantly, my lord, so that we do not want to hear these accusations about, oh, somebody is trying to delay this matter. We are the victim, and I reiterate that. For purposes of the petitions before you, we would like this petition had as of yesterday. And we kept on saying yesterday, the petitions to be had. My lord, these rules, because it's the enforcement of the constitutions, the Mutunga rules applies. Since the Mutunga rules applies, the applications of the Mutunga rules was everybody was supposed to respond even to the petition to get the matters rolling. There have been no compliance with Mutunga rules for purposes of the respondent. So that if anybody was to be accused of any delay, it would be somebody who has not complied with the Mutunga rules. That is issue number 1. Issue number 2, my lord, was this, that even for purposes of consolidation, the consolidated matters, some of the advocates led by my colleague, Ms. Kimovo, they were not even served with the applications that the respondents are itching to have them disposed of. So that, my lord, because of that mess that was created as of yesterday, and the fact that we do have now a notice talking about these matters, the truth of the matter is, unless we have a situations where some of the advocates in the four matters that were not there yesterday have not even been served with this notice, and I know them. So that unless now we take a fresh date without somebody waiting to say that, oh, this court must discharge orders and we have a swearing in over the weekend, the truth of the matter is we need a clear date where the court ensures everybody who ought to be before you, particularly based on these issues that has been raised courtesy of correspondence with the Chief Justice, is addressed. But somebody to pretend, oh, I want to lift the conservatory order and the other side is delaying, it is unfair. We want the petition heard, and it starts with compliance with the Mutunga rules, which there is no compliance whatsoever by the respondents. So that, my Lord, I beg you that let us not appear now to be saying, oh, somebody is playing to the gallery. Nobody is playing to the gallery. We just want to assert everybody's rights. And these rights are very easy to enforce if the Mutunga rules are going to guide these proceedings. My Lord, I beg you to have the information of that.
Your Lordship, I had just wanted to highlight the content of the notice which you received.
I think we'll talk about the notice. I said just sit down. We won't talk about that notice.
Your Lordship,
I will talk about that notice before you speak.
My Lord, do I have your permission to address it?
Yeah, even if the court wants to talk, you don't want the court to talk. Dr. Kamino, let me address the issue.
Oh, I'm sorry. I apologize. No, I apologize.
I think we have made it very clear in the ruling which you have just delivered that the matters before this court are very important to the people of this republic. And you will appreciate that petitions are still being filed throughout Kenya. When we retired yesterday, we received several empanelment of matters of which we gave this notice. Therefore, don't think you are the only person who are in these petitions. There are also other Kenyans who are coming day in, night out. So the matters which you've set out for mention are the matters in which we have been empaneled as from yesterday. So you wait for God to give directions, then you start talking. You cannot just start talking from the air without facts. Let us mention these files first, then from there, you'll see the directions emerging, and then you can make your prayers. Let's mention these files first. The other clarification is that we have two cohorts of petitions which have been consolidated. The first cohort were the petitions which were filed to challenge the processes both in parliament, yes. And during that time, this bench consolidated 6 petitions, with the lead petition being 522 of 2024. Is that correct? That petition, number 522 of 2024, is the lead file in the petitions which were filed before the finalization of the matters in the Senate. Then, after the proceedings in the Senate, other petitions were filed. And with you, we consolidated all those petitions yesterday. So we have 2 running parallel petitions before the Senate proceedings and after the Senate proceedings. You will remember that petition number 522 was, we listed it for mention on 29th of this month. But because of need to know, because I know there could be cross-cutting representation in these petitions, we decided just to call it because we knew that all of you would be here, so that if there's anything you want to say on those petitions, you can say it. So that's the reason why we have petition 522 here for a mention. There's nothing to be mentioned, but we said since parties are likely to be here, and some of the parties were even asking for it yesterday, so we brought it. But the other petitions to be mentioned are specific petitions where we have been empaneled. And we wanted to find out the way forward, whether we can consolidate these petitions or whether they can be done separately. So these are petitions number, let's mention petition number 570 of 2024, AD Waiguru and Victor Gatia. Yes, this petition.
Yes. My Lord,
excuse me. Where are the Qurans? Put Qurans in these matters. Just a minute. Yes.
My Lord, in this petition, this one was filed by the law firm of, I believe, Mutembei, and it's called what? Mutembei, Gachagua and Company Advocates. I am aware of this petition for the simple reason that he had requested me that when it comes to the hearing, I appear alongside him.
Alongside who?
Mr. Mutembei Marete. But, well, the parties are many, starting with the first respondent, I think is President Ruto, regarding Gachagua is the second respondent, and there are others. My Lord, for purposes of this petition, it was filed on Friday, and by Judge Mamuye, referred it to the Honorable Chief Justice, and we expected it to be coming tomorrow on Thursday. My Lord, Mr. Mutembei was not served with this particular notice that is before you.
Actually, nobody was served. We sent out the notice in the morning today because we received them in the morning. And that's why I said that this matter is coming.
Yes.
And because the representation is likely to be approached, we mentioned them because we thought we'd find people like you waiting for them here. Yes.
So that, my Lord, in that case, what I would ask the court, and for the additional reason that I am aware that in that matter, the notice of motion is seeking a 5-judge bench, and particularly for the reason that this is an application by the citizens of Central Kenya who says, like in the year 2013, that their rights, not just regarding Gachagua, would have been affected adversely by the impeachment of the Deputy President Gachagua, and therefore I would ask that this matter do come tomorrow so that the issue on that issues of empanelment and in the presence of Mr. Mutembei can be dealt with. Because now that it is obvious that even the direct, like the advocates who filed the case are not here, it would only be fair that there is another mention where they can also be there. Actually, we didn't even have the file. We are just looking at it from our record. But that is the position as far as 570 is concerned. It's a specific application for a 5-judge bench in that matter.
Mr. Kibe.
Yes, my Lord.
We are beyond that. There was a request for a 5-judge bench.
Yes, my Lord.
But what has been empaneled is a 3-judge bench comprising Justice El Kugola, Justice Mrima, and Honorable Dr. Justice Freda Mugambi. So the request for a 5-judge bench, I think, is overtaken by events unless he wants to appeal.
Yes. the chances of appeal are very high. for the simple reasons, my lord, that will become apparent. I believe there must be some mechanical applications to the issues, but now that it arises specifically, that issue will be addressed, and the Chief Justice will have the relevant communications tomorrow morning, while given the nature of the issue that must be dealt with, there must be a 5-judge matter. All benches can be expanded. I believe that is the position that we are coming from. So without saying specifically that we don't want anyone, all benches are capable of being expansion, particularly bearing in mind, and this is something that a number of the clients that already we are representing, there have been repeated insinuations by our people out there, including Senior Counsel Abdel-Nasir Abdullahi, that the senior bench is supposed, the judge bench is supposed to do this or the other. We can't help that. This is not.
So what we'll do, Mr. Mugai, is that we'll mention this matter tomorrow.
I'll appreciate what
Yes.
time now.
At 9.
Most obliged.
But Mr. Kibe, you will serve.
Most of the people actually here, we have served them, but we shall serve the notice of hearing.
All right.
The notice of hearing for the mention tomorrow at night. I thought my Lord the time would have been in here, because by the time I go to my office, there will be nobody to do some of this.
You know, by the time we spend here means that even if you come at 10, you will find us here.
And at what time then do we come tomorrow?
The court starts at 9.
Yes.
You can come at 11.
11.
Yes.
My Lord, I am asking please, in this particular file, that you record my presence together with the other lawyers I mentioned earlier as appearing for the Deputy President with the second response.
This one?
Yes.
The verified?
Yes.
But you didn't stand up, Mr. Mute. I thought you were not here. This matter of 570?
Yes. If you look at the party, the Deputy President is the second.
Okay. So you agree with the directions which you have given? Eh?
I accept the direction. And I will be here tomorrow, I think. Inshallah.
Yes.
Mr. Lordship, this particular matter.
Let's the same matter.
Yes.
570.
Yes, my name is Manzo. I wish to go on record for the first interested party.
Your Lordship, my lady, may I be placed on record for the second and the fourth interested party? And permit me to only indicate the implication of the orders of the Parliament that were issued by the judge who directed the Chief Justice does empanel you. To the best of my thinking and knowledge is that the prayer was granted as it is for the empanelment of 5 bench, 5 judge bench.
Mr. Jiru, yes. We speak from the record. You heard me mention the parties. I said that this file has been empaneled to comprise the Honorable Mr. Justice Eric Ogola, the Honorable Mr. Justice Murima, the Honorable Dr. Judge Freda Mugambi. I think that's very clear. We are only 3.
That's correct, but I will address it tomorrow.
My lord, my lady. So we mentioned it tomorrow. Mr. Njiru, you say you come for which parties?
Your Lordship, I appear for the second and the fourth interested party.
Thank you.
My Lord, perhaps if I may make a request. My Lord, there is a file that is live before, and that is petition number 565 of 2024. We have requested, my Lord, that you give directions in respect of the applications in that matter, because this process of taking quorum might take some time. And there are 3 cohorts of files that are before you. And if I may just be given a moment to explain myself. As the court has correctly identified, there is a cohort of files that are consolidated in petition 522. There is a cohort of files that is consolidated around petition 565, which have the 2 applications that the court has identified as urgent. And then there are these others that have been referred to the court by virtue of the email that we have all seen today. It is my request that the court keeps them in those cohorts so that the applications are able to be dealt with because they are urgent. These are important, but the applications are urgent. And the court has identified that urgency because this will go on for 2 or 3 hours without any directions having been given in 565.
Lord, could we be on board together? We are being made orphans. The state is in the bedroom. Let us also be in the bedroom so that we can respond.
Mr. Ahmad, what do you want to do in the bedroom?
We will discuss our plan. Can we allow the parties?
Mr. Nyamodi, the reason why we are mentioning these matters is to find out if any of them would be ripe for consolidation with the matter which is here so that we don't duplicate.
Thank you. My Lord, perhaps as you consider that, let me put it on record that if you are considering whether they are ripe for consolidation, the consolidation should not then slow down the hearing of the application that you have already identified as urgent. If they are to come on board, they come on board and proceed from where we are.
Yes. Let us be on board first. We will respond to you appropriately.
Okay.
Allow us to be the real estate platform.
Give me the next.
My lady and my lords, I just have a passionate plea. There are not many pleas. The first plea is we consider utilizing the ceremonial court on the ground floor because it is spacious and sufficient for all of us. That's number one. Number 2, my request is this. The court has all the petitions. Why can't the assistants to the court enumerate the parties there in the quorum in the manner we used to do in the Court of Appeal before? So that when we appear here, whatever time you indicate, we just fill our respective names and the court will be able to deal with the matter without the need of this back and forth. Number 3, my lords and my lady, I think the court needs to just be a little bit proactive. When you retreat, you may make 2 decisions. One, either to determine the interlocutory applications, in which case you can frame issues for the parties submitted. Or 2, if you're minded to hear the petitions themselves, then still frame the issues and forward it to us so that we're able to make progress. That way we'll make good use of the judicial time that is very limited in this matter. I beseech you more.
Thank you, Mr. Harvey. Well taken.
As a former chairman of the society, let me second the first issue and plead that if only for the purposes of everybody getting sufficient oxygen, if we are too crowded, and the people want to listen, and the media and the members of the public, if it is possible, let us use the ceremonial hall.
Council, Senior Council, we will use the ceremonial hall as from tomorrow.
Thank you.
And
I wish to say that perhaps when giving directions, then and if parties, files are going to be consolidated, then it would be proper each person is served with the applications so that we are able to respond, even if we are given a day to respond, so that when we begin to submit, we are able to submit according to the law, not as per the bar and whatever issues are being raised. Thank you.
Thank you.
My Lord, I was going to beseech the court, if we are to make progress, I will beseech the court to invoke its powers under Section 5, Article 159. We will go on and on. There is no shortage of legal provisions enabling this court to rein in on the lawyers. Because if you don't do that, my Lord, on a matter like this, where you have 20 lawyers, 50 lawyers on the other side, we will be coming to you. We'll be doing legal gymnastics, legal ping pong, what I call legal sophistry on other occasions. And meanwhile, we'll be lamenting as we are now lamenting to you. So there are applications, both from this side and this side, certified agent. Meanwhile, we are spending a lot of time, each of us from whatever side, studying to raise this or other housekeeping issue. I beseech you, my Lord. In a matter like this, the court must be very firm. It must run the country. The court itself must have very clear direction. Which is the application that will be had, in what sequence, what are the time allocations, how the parties share those times.
We have agreed on that, and what we ask is let us mention these matters so that we know how they relate to the other matters which are before the court. So we have mentioned 570. We have mentioned, do you have 570? We have mentioned 570. There's, which one did we mention? This 550. 550. We have mentioned E570. E550, Speaker of the National Assembly versus Brigadier Gachagua.
My Lord, this file is already consolidated under the cover of the 550.
$550.
When was the petition filed?
No, sorry, my Lord, that was not.
Yes, 550. Who is in 550? Who is in 550?
My Lord, mine is 572.
I'm asking 550.
Yes, my Lord, 550. My Lord, we appear for the first respondent.
I guess you can tell us who is the petition.
The petitioner, my Lord, is the former deputy president, my Lord, represented by Madam Senior.
My Lord, I appear for the deputy president, not former. He remains in office on the basis of the conservatory orders, and each bench has confirmed weighty issues, which is why we are here. It's not during the rush.
For the first petitioner?
For the first petition. I thank you.
My Lord, if it pleases you, Nyamodi and Gumbo for the second respondent. And our learned colleague, Mr. Murugan.
Yes.
That matter, my name is Mukele. I appear together with Andy and my senior Professor Jenda for the third and fourth respondent.
Yes.
That's all.
Who else is in this matter? So for the petitioner, Mr. What are the issues in this matter? Are they relevant to the consolidated petitions?
The petitioners are. There are so many files here.
This is
the same team of lawyers.
Yes.
Including myself that I gave when we came for the ruling.
Yes.
Is appearing for the deputy president.
What I'm asking is it going to be consolidated or is it standalone?
One of the ones that we are consolidated.
Sorry if I appear.
Yes, speak, please.
For you to be able to progress, I beseech you to adjourn this matter tomorrow. Go and make directions. You're either hearing the petitions or the applications. Come here so that we have a perspective upon which to focus. Otherwise, we will not.
We are alive of that fact, Mr. Harvey, but
It's my advice.
it is the councils who will be saying that their right to be heard, even on petition, even if the slightest issue has not been granted. Therefore, let us agree on the way forward. If you make a proposal can come from you your side, how you want to deal with all these petitions. Is it possible that you want to ignore all applications and proceed to the petitions? You can make a submission which this court can consider.
My Lord, if I may, just to guide the court, and on this account, I will do it as senior counsel. My Lord, there are urgent applications before you. The applicants or the petitioners at their bite yesterday on a preliminary objection that the court has ruled on this afternoon. My Lord, we have an urgent application that was filed before you, dated 18th October 2024, for discharge of the conservatory orders. Whatever decision this court makes can be either way, will lead to directions on the hearing of all the consolidated petitions. Some of the petitions, my Lord, deal with issues or causes of action that arose before, my Lord, the impeachment. The proper position of the law is that the party who is the petitioner is the former deputy president. That's the position of Article 145(7). Allow us, my lords, to urge our application for the setting aside of conservatory orders. I think, my lord, that's the only way we can move, because they have had their bite, let us have our bite as well. We will only take 30 minutes, we request.
I'm not disagreeing with you, Professor Gianda. What I'm saying is that let's mention these files. We are on the third one, and if you have not been interrupting, perhaps we'll be through with them. 550, I've recorded the quorum, and what I asked, is this file related to the files before the court? For the purposes of consolidation, or it can stand alone?
Can we deal with that?
Because there's a...
Consolidation has implications. We need to consult my team, we need to consult the client. Let's take the quorum, let's deal with the consolidation.
So we'll mention it tomorrow.
Yes.
Next. 541, Dr. Clarence Eboso. Dr. Clarence Oboso.
May it please the court. My name is Dr. Clarence Eboso. I'm the first petitioner in E541. The petitioner is between Dr. Clarence Eboso, Ms. Wanjiru Mwangi, versus the Speaker of the National Assembly, the Attorney General, and with the Law Society of Kenya as an interested party. The petition relates to the process of impeachment, particularly in the National Assembly, and seeks orders to quash the proceedings in the National Assembly. The petition has an application which was certified urgent and which sought an injunction against the entire proceedings of impeachment. The court which certified it urgent directed that the application would be heard by the bench that would be constituted. Several of the prayers that were made in the application have since been overtaken by events. However, the substance of the application sought to conserve the issues as they were, and therefore the conservatory orders that were issued by the court in last week on Friday protected some of the prayers that we had made in the application. Yesterday, I pointed out to the court that proceeding with the discussions on the conservatory orders would have prejudiced us because then we would have lost out without participating. Our prayer would be
No. It's arguing the application. They're taking so long.
Just tell us, Mr. Clarence, whether this petition, you want it to stand alone or whether you want it to be consolidated with the petitions for the court.
That's where I was going to go.
Just go there, please.
I would be seeking that the petition be consolidated with the petitions relating to both the impeachment process and the filling of the vacancy that arises from impeachment. The reason being, upon filling of any vacancy.
Okay, we have heard you. You are agreeable to this petition being consolidated with the petitions which are in file number 565 of 2024.
My Lord, may I just conclude? My Lord, may I just conclude that I will be needing to compromise our application, provided that we can be allowed to participate in the applications for conservatory orders that are before the court in the interest and time.
With your permission, my lord, I appear for the first respondent.
Yes.
And my lord, I noted that we didn't come with our file.
Is this petition post Senate proceedings?
No. It has not been. It was filed, my lord.
Before.
And it has not touched on issues, my lord, that happened at the Senate. Ordinarily, my lord, would be opposed.
So we mentioned this matter.
Tomorrow, my lord.
We mentioned this matter on 29th when the petition number 522 will be mentioned.
Most of that.
Yes.
I'm not sure if the court got the last statement I made. It would be very prejudicial to us if the discussions relating to the conservatory orders continue without our participation, because we are essentially raising the same issue in our application.
My lord, I agree. As we filed our application on the 8th of October 2024, before the National Assembly had even made its impeachment, had impeached them to regard Gachagua. We are acting in person, we are laymen, my lord, and we are also protected by the same laws, Article 27, Article 47, 48, and 49, and 50, my lord, for the right to a fair hearing. So we do ask the court does mention our matter tomorrow so that we can articulate the points that we need to.
Well, my lord, I appreciate the fact that the petitioners are appearing in person. My lord, once the court has made an order, my lord, the only remedy available to the parties is either to appeal, my lord.
We have not made any order. You know, we talk before the orders. So we mention this matter tomorrow.
Be available.
Which one in there? $572. 572.
My Lord, the presiding judge, my Lord, my lady, Dr. Princess Unimati. My name is Wamboi, Shadrach Wamboi. I have the honor and privilege of introducing counsels for the petitioner. I am here alongside my learned senior, Mr. Dunstan Amari.
I'm present.
Mr. Samson Nyaderi, my senior.
I'm present.
My learned colleague, Mr. Nicholas Karanja.
I am present.
And my learned colleague, Miss Melissa Omeda. We all are here for the petition applicant. Thank you.
Yes.
My Lord, in that matter, I am Shadrach Moses, the Solicitor General, appearing for the Attorney General, together with Professor Gitu Muigai, Senior Counsel, Emmanuel Peter, Deputy Chief State Counsel, Charles Mutinda, Deputy Chief State Counsel. Much obliged, my Lord.
Thank you.
My Lord, if may please in the matter, I appear alongside Ole Kuyoni for the first respondent.
Thank you, my Lord. For the second respondent, my name is Gumbo. I appear together with the learned senior colleague, Ms. Paul Modi,
and Mr. Honorable Bitonga Mroga. Please, my Lord, my lady. That matter, my name is Kelly. My Lord, I appear together with my senior Professor Ugenda. My Lord, Senator Hilary Sigei, and Ms. Mercy Tanki for the third respondent, my Lord, in this part of this.
For the third respondent.
For the third respondent, speak of the Senate.
The Deputy President is the interested party, and I appear with my colleagues, Mr. Ngoya, Mr. Macharia, Jomo, Degwa, Kempa, Ondati, Victor Swanya, Faith Muge, Faith Oigo, Mr. Muge.
And Mr.
Muge, for the interested party, that is the deputy.
Thank you, my Lord. My Lord, just to respond to the question whether this petition should be consolidated with the others. The questions that have been posed in the instant petition question the constitutionality of the impeachment process at the Senate that led to the removal by way of impeachment of the Deputy President. Secondly, my Lord, it also questions the constitutionality of the appointment of Professor Kithure Kindiki as the Deputy President designate in that office. And for that reason, my Lord, the view that we take immediately is that the petition is ripe for consolidation. And my Lord, just for the avoidance of any doubt, and my lady, we have an application filed and dated the 18th day of October 2024 that sought an order of conservatory order to stop the implementation of the decision made by the Honorable Speaker of the Senate, Honorable Amos King. So, my Lord, when we canvass or we are to canvass the applications as to whether the current conservatory order should be disturbed or not, we want to actively and we seek humility to participate in those proceedings. Thank you.
Mr. The parties, are you opposing the possible confirmation?
Yes, my Lord, we are vehemently opposed, my Lord, to the joinder or intended consolidation of this petition, and also that we don't take time before you this evening. We would prefer, my Lord, that this matter also takes the cue of being mentioned tomorrow with the others, my Lord, where we will substantively, my Lord, be presenting, my Lord, before you reasons why this matter should not be consolidated with the one that is before you today. And my Lord, so that we save time, I speak for all the respondents.
Mention tomorrow.
Sorry, madam.
Mention tomorrow.
We mention tomorrow.
My Lord, if you permit me. My Lord, there is a mischief that we need to cure or to safeguard ourselves against. My Lord, there is an attempt to have a litigation by way of installment in this matter. So much so that, my Lord, if you look or you find time to look at the petition and the application, you will see that the issues that are raised by my seniors and counsels for the petitioner are synonymous, they are the same.
So since it is not consented to, why don't we listen to it tomorrow?
Most obliged, my lord, because the question of consolidation is a question of law and it's purely on a principle question. And my lord, we will be ready to argue the question of consolidation as and when we are invited. Thank you. Yes.
Proceed.
And my lord,
Yes.
Yes, I am guided by my senior counsel, Paul Muite. The question of consolidation is one that even the bench, as it is currently constituted, can actually look at the matters and on its own motion, so moto, give directions or orders, whether it is deserving to be heard alongside the other matters, or we just need to take a cue behind other petitions.
My lord, the court has spoken. We'll mention it tomorrow. Thank you.
Let's consider that issue tomorrow.
Most obliged.
572. 522. 522. This file has a mention date for 29th of October, but because issues are arising, we wanted to mention it again today if there is any issue arising out of it.
In terms of appearances, and in order to save the court's time, the same counsel that I enumerated are appearing for the petition, the Deputy President, in this one.
Yes.
Yes, my lord, for the respondents, a quorum, similar, my lord, so that we save on time. My lord, we will be reading, my lord, to present the purport to us. Either, my lord, we retain a mentioned date that is been given, or, my lord, you mention the matter tomorrow, so that if there is anybody who want to address you, we address you tomorrow, my lord.
We don't want to talk tomorrow with so many matters. If there's no need, we can return the 29th.
We can return the 29th, my lord.
Okay, we can mention it tomorrow. Let's mention the matter tomorrow. So we are clear with the mentions. We can go back to petition number 565.
No, you've not mentioned my matter.
Which one?
509.
509. It was consolidated in 5.
Sorry, I'm sorry, I never had you call it out. I'm sorry, Mr. Kip was keeping me busy giving me. My lord, in that respect, we have an application. I hope it's on record. We could also mention and get directions tomorrow on my application for the recusal of the bench dated the 22nd. I would be most obliged, Lordship.
We are mentioning the matter tomorrow.
Most obliged.
So then we are back to the petition number 565.
We wish to confirm that on the part of the Attorney General of the Republic, we are ready to argue our application certified urgent by this court, or by the court referring the matter to this court.
I believe this is the matter that we had earlier indicated, that after all these matters have been consolidated, directions have been given in these matters, specific directions need to be given for purposes of that matter. And for purposes of enabling those specific directions to be given, I want to point out three things. Number one is that we would need directions on when the first application that was to be done after the validity application is determined, when we are going to be had. That is issue number one. Issue number two, my lord, that is important, is the fact that now that today the Honorable, the Chief Justice has caused all of us to come on the basis of these other matters, the point needs to be noted that for purposes of the basis for all these matters that empanelment was done, the reason was that there were applications for conservatory orders. Those applications for conservatory orders were first certified as urgent and would be the first business of this court appearing there, assuming there is no other preliminary issue like recusal or otherwise. Thirdly, my lord, is this, that for purposes of those applications where conservatory orders were made, the conservatory orders may have been made in 2 or 3 files, but they conserve the status, quo that is cross-cutting in all the petitions that are before you. Apart from the fact that in that particular petition, the one that has conservatory orders, when this court, because all those applications were done on Saturday, the parties, starting at least with those that I represent, because of the nature of the proceedings that were there yesterday, we have not completed doing the responses to the applications by the Attorney General to lift conservatory orders. We could not be able to do the authorities for reasons that were indicated. And more importantly, my learned colleague, Mrs. Kemogo, whose file has been consolidated, did indicate she has not even been served, and in that matter, she needs to respond and be heard. Therefore, my lord, in considering this issue that is itching the group that wants lifting of the orders, I would like the court to give directions bearing in mind that the stakes of the parties, all the people who have filed petitions, is to ensure you are not faced with a fait accompli, where you are told, we have already sworn Kindiki and you can go to hell. We do not want to be faced with a fait accompli situations. My lord, it would be absolutely important that the subject matter is preserved, if not for any other day, until all the parties are before the court.
Your Lordship. Your Lordship, there is
Yes, you can see that we are consulting.
Now we will proceed in these matters as follows. By tomorrow, we will issue comprehensive directions on various issues. But importantly, parties are already aware that there are two cohorts of matters. The first cohort involves the petitions which were filed challenging the happenings before the National Assembly. Those petitions will proceed as cohort 1. They are the subsequent petitions which were filed challenging what transpired in the Senate. That is cohort 2. By tomorrow, we will deal with the issue of consolidation. We are aware of the powers this court has on the issue of consolidation, just like how we exercised the powers yesterday. We may decide to either hear or give directions on the consolidation. However, we are in agreement that the next application in line can only be one, and it is the application for recusal of this bench. And that is the application which, after we do everything, tomorrow at 2:30 is up for hearing. If you intend to participate in that application, in the second cohort, that application is coming up for hearing tomorrow at 2:30. In the morning, we will deal with the issue of consolidation. That one we will give directions on that. So that is the way forward. Prepare to hear the application for recusal of the bench tomorrow at 2 p.m. In the morning, we will deal with the procedural issues of consolidation and any other issue which may arise in cohort 1 and cohort 2. Thank you.
And those are very clear directions about the election. And we entirely agree that we will assist in the orderly progression of the hearing of this matter.
Just for the record, my lord, we assume it is all the 3 applications for recusal because
There will be no other application for recusal. We will hear what is on record, and it will be a ruling will be delivered. There will be no other application for recusal. And we think that that should come first because if you don't want a bench, there's no reason why we should do any other thing.
My lord, I was only pointing there 2 or 3 of them.
Yes.
And the only clarity I'm asking is whether all applications for recusal will be handled together.
Yes, together, all will be handled together.
Your Lordship, finally, as you categorize these pleadings in cohort 1 and cohort 2, I kindly allow me to remind the court that the last time we were before you on the 16th, the court gave or granted leave for parties to amend their petitions. So there could be petitions that have now crossed over to cohort 2, pursuant the amendments bringing in light what transpired. Perhaps the pleadings will just witness.
Mr. Legwa, those are some of the preliminary issues which we'll deal with in the morning. But principally, prepare to argue your application for recusal at 2:30.
I am ready even now.
Before we read, and with your very kind permission, I would like to put the deponents of the affidavits that have made very, very grave allegations about judges of this court to be present tomorrow at 2:30 because we reserve the right to cross-examine those deponents and to move the court as appropriate after that.
Well, perhaps if I may request that the court supplies us with a typed copy of the ruling that you have delivered today. We know you are working under very tight timelines, but we very much appreciate a typed copy of the ruling that you have delivered today. We believe it may be useful in the tasks at hand tomorrow.
Finally, Your Lordship, this is the ruling that you delivered on 16th of October in the consolidated petition 522. And maybe you can get a copy of that ruling.
The ruling should be available. So, yes.
Finally, my judges, I think there is an hullabaloo about service, that there are some parties who are present and have not been served, and we've been hearing this from inception. I think tomorrow we settle the issue of service. We also settle the issue of filing of any affidavits or responses that ought to be done, so that after 2:30, we know how best to do it.
The next conversation we want to have is on impeachment, okay? So recently we were treated to
Thank you so much, everyone, for being with us. It has been long. It's almost, it was like 2 hours about the judgment that was being made. Actually, now, from the look of things, it means that the preliminaries hearing is kind of over. So, what to me, what I would say about today is one of the issues that was being raised by the petitioners, I think, has been answered, and that is the issue about the CJ, whether the CJ was has powers to assign the panel. Actually, that one has been answered, and it is lawful. Like the CJ acted lawfully to assign the panel. So those are some of the issues that I think were there, and so many, and consolidation of the files too. I think that one will be coming tomorrow. And another issue that was being raised by the petitioner that will be discussed tomorrow is about the recusal of the bench. Yeah, so that is also something that we will be looking at tomorrow. So hopefully, then from there, now I think the real hearing will kick off, and that one will be. I know we will get to know whether the impeached deputy president will be reinstated to the office, or the Kindiki, or Honorable Kithure Kindiki will be sworn in. As you know, he's the deputy president designate. Hey, Miguda, habari gani? Hello, Miguda.
Ndugu yangu uko vipi?
Niko salama, habari gani? Hey, habari gani kaka? Okay, thank you so much. I think Miguda is still setting up his part, so we might try to weigh out some few options here, or we can try to. Hey, habari gani?
Salama, uko vipi?
Mi niko salama. Tumekuwa tukiona vile mambo inaendelea hapo kotini. Kuna baadhi ya vitu ambazo mimi nilikuwa nasema kwamba nimeona. Kitu ya kwanza, jambo la kwanza ambao mimi nimeona hapo ni kuwa hii kesi si kesi tu, unajua, si ati kesi tu ya kawaida. Hii ni kesi ngumu kabisa, na ukiona mawakili ambao wako hapo ni wengi sana, na ni wale ambao ukiangalia katika nchi yetu ambao tuseme ni mawakili ambao wamebobea na mawakili ambao wamesikiliza kesi mingi na za hali ya juu. We, maoni yako ni vipi?
Sijui kama unanisikia?
Nakusikia vizuri kaka.
Kwanza tumekuwa hapo mahakamani
Yeah.
na tumeshuhudia ya kwamba vile umesema hii kesi ambayo iko mbele ya hakimu jaji Ogola na wenzake wawili, Mugambi na mwenzao.
Yeah.
Ni kesi hii, si kesi ya kawaida, si kesi, si vile unajua, si vile watu walikuwa wanatarajia matokeo.
Yeah.
Uliona kabla ya hakimu kupeana uamuzi wake, wale mawakili kutoka eneo la naibu rais Rigathi Gachagua walikuwa na furaha tele, lakini baadaye ukapata wameshikwa na huzuni. Sasa hata hao mawakili katika mahakamani hawajui yale yanatokea, na pia unaona kama kuna zile madai mapya bado yanazidi kuongezwa katika hii kesi. So naona tu ya kwamba kuna ugomvi hadi katika mahakama. Watu wameenda kwa mahakama, kuna ugomvi katika wale katikati ya naibu wa rais Rigathi Gachagua na rais William Ruto. Sasa hiyo ugomvi imefika mahakamani, ndio maana pana ya kwamba hiyo kesi bado kuna zile madai zinaongezwa tu baada ya kila muda, hata baada ya jaji kufanya muamuzi, bado kuna madai zingine zinaongezwa na wale wakili wanaowakilisha naibu rais. Sasa hii kesi nyingine ni ngumu, lakini pia ni kesi tamu sana, tunafaa kuisoma kama wananchi.
Okay, Asad, thank you so much, and it is okay. You know, as you said in Kiswahili, kesi ni ngumu sana. It is high profile case, and it is one thing that I'm seeing with this case. It is testing the elasticity of our constitution. You know, I've been one person that has always said that the 2010 constitution, that the political class might have had was so much ahead of the wananchi, and there's some clauses that they might have been in place that would favor the leaders, and but today and how now things are, I'm tending to have a different view of it, because it is giving me another picture of this constitution that I was not seeing before, just because it has never been tested on such like areas. Maybe your thought?
Yeah, it is good that you had Justice Ogola was categorically that our constitution is transformative.
Yeah.
And we have been saying that time that number is a transformative constitution. And now today the at a state is the one we quoted, said that Article 165.4, that whether the Chief Justice shall appoint a bench of judge to hear and determine substantive question on the constitution. So that is what was at stake today. And you have even had the way Justice Ogola has categorically cited, and also the rulings by the previous court, and it was very specific, the ruling by W. Mutunga, the Chief Justice Emeritus. And you know, he based his argument on the context of the constitution. He never deviate out of it. And it was even quoting article, I think 259.2, and the article 20, that brings you to the issue of fundamental freedoms and basic human rights. There you find, but you have freedom and dignity to an extent that if your right is infringed, you can go to that court to seek justice. So it was very categorically within the ambit of the Constitution. It never deviate out of the Constitution, but introduced something which was very unique, Brother Benson. Let me quote it here.
Yeah.
And I've also learned something very new today, that, you know, we have said here that Chief Justice is the president of the Supreme Court, is the head of the judiciary, and the chairperson of Judicial Service Commission. But today is introduced to us that if you look at the Judicial Service Commission Act, that provision of the membership of the judiciary, Judicial Service Commission, the membership of the Judicial Service Commission, Chief Justice, the chairperson, but Deputy Chief Justice is not vice chairperson. Are you seeing that contradiction?
Yeah,
Yeah.
That is
So
one. Yeah.
it doesn't mean that if I am chairperson everywhere, when it comes to the Judicial Service Commission, the Deputy Chief Justice does not deputize Chief Justice. So it means in the Judicial Service Commission, they have a certain deputy who deputizes Chief Justice Commission among those 9 commissions in the JSC.
Which means it cannot be the Chief Justice to be your deputy. It can be somebody else.
Yeah.
So that's okay. That also.
That's something which the Justice Ogola just enlightened me about our formation of the JSC Commission.
Okay, thank you so much. Because you know, like I was there listening keenly because I don't have a law background, but being a citizen of Kenya and I'm very interested on what is taking place in our country, you know, when you go to online or when you go to platforms, like each and every senior counsel or anybody with low background and all those without low background, everybody was giving suggestion. And like if you're somebody who does not have that low background or the constitutional background, you are left in balance because you don't know where you should be. You know, you will listen, which one should I kind of like be convincing to me. But what I came to realize in the public is that if you are supporting Rigathi Gachagua, anything that favors Rigathi Gachagua, to you, that one will be what the law says. Yeah. And if you're not supporting Rigathi Gachagua, when another council or anybody with a low background says something that does not favor Gachagua and favors maybe the impeachment of Gachagua, that will be your take. As that one, have you realized that or not?
I've realized that because, you know, whenever any council who is representing the deputy president, Rigathi Gachagua, the impeached deputy president, Rigathi Gachagua, those people who are allies to Rigathi Gachagua, they seem to be happy even in the X-space. You see the way they are praising such advocates that Ongoya, president. But whenever any petitioner, any respondent advocate also stand out in his or her submission, the people who are against Rigathi Gachagua are seeing them that they are winning. And I told you in this channel that you cannot know the outcome of the case because of the submission of the advocate. The outcome of the case can only be known by the time the judge is going to make the final determination. Because, you know, even by the time the Ogola was introducing his decision or determination, people were seeing it going to the favor of Rigathi Gachagua, you see. So this issue, the advocate will always give you a hope because you are the client and you have paid him or her to discharge that mandate. So there is no way you cannot try. You know, this is a contest. It's more of a football match whereby you have to try by all means to outshine your opponent. So the outcome will be determined by the final whistle. So the final whistle here was the judiciary. And I like the way Justice Ogola was driving his rulings because there was that composure of the ruling and it categorically rely on the Constitution's articles and Constitution's provisions. It never divert out of it, and furthermore, introduce some of the ruling which has been made before by the same judiciary. That it was referring to the ruling made by Dr. William Mutunga, former Chief Justice, by the time he was in the office. And also, he relied on the Judicial Service Commission Act, where the composition and the role, and he distinguished that the Article 165 for then also introduce that Article 159 of the Judiciary and also include the Judiciary Act. So it means that he include all the authority in his determination of the ruling. So Justice Ogola has made, now we have distinguished that now between the submission of the defense counsel and the respondent. So going forward, you have also seen there have some addition of petitions, additions of applications. That's why I say that it is a bit of a complex case, because this is the first time we are witnessing the country. But at the same time, it's a very interesting case to learn, because it's going to set out a precedent that will be used for the future years to come.
Okay, thank you so much. And one of our viewers, Godfrey Kinyoru, is asking, then he can resign thereafter. Yes, my assumption is this. I'm not very sure if the judgment will favor Rigathi Gachagua. To me, due to the fact that their relationship with the president might not be such well, I feel that he will have that option of resigning. Yeah, and that one will help him to chart his political ways. That is one. That one will be his way. You know, we cannot kind of force him. And another thing, I can also insist, so that he can enjoy the privileges, you know, that come with the office of the deputy president. But I know maybe the funding and all that, the security, he might be given security, but not as he used to have. Yeah, but he can also decide to stay. But I think the bigger thing that the deputy president might be fighting is fighting for his political life, because if the ruling will go against him, you know, it has a repercussion, especially in political career. He might not vie for any political office. So what is your thought on what our viewer and subscriber Frederick is asking, whether to resign or no?
Yeah, it's a question of debate,
yeah,
and that is the discretion of the deputy president. We have even had Senior Counsel Paul Mute addressing the court that the issue of them appealing is a discretion of the client, because they cannot make a decision on his behalf. So whether he's going to resign or not, that is his own decision. But if you want to secure his political career, you ought to have resigned going forward, because maybe if you want to be a politician in future, but sometimes maybe you can decide that I'm done with politics. I've had my time, I've had my day. This is how it has ended on my side. It happens to people. Then let me just kill my political career and focus on my private personal businesses. So it is that a discretion of Rigathi Gachagua to make decision whether it's going to make a comeback or not. Making a comeback or not, it will depend whether it's going to resign as the ongoing cases is on. And also, I could view it in this perspective. You know, Rigathi Gachagua has been accused of some allegations of maybe not only subordinating the president, but there are some allegations like corruption. So maybe you want to deal with these cases of corruption, that is done with them once and for all. So even when he's at home, there will be no time for him to come back to court to settle. So he want to settle everything with this window which has been given in the court. So he can go to the Supreme Court, but at the end of the day, the Supreme Court will stop him from vying in the future, but all the allegations will be quashed away. So he'll be a free man. He will go home as a free man, even when he's not going to come back to politics. But he will go home as a free man who has faced all his charges and he has been acquitted. So he's at home but free. Not that he's at home, but maybe he's waiting for some future charges. So maybe I'm looking at it on that perspective. He might be want to deal with this process so that once it's done with them, he's going home as a free man, as an acquitted man in the process of all these charges.
Okay, thank you. There is a corruption charges filed against him. Okay, that is there. So those are he is fighting them. And you know, this was a political process, and anything, the weakest point of the weakest side that somebody have against you can use it so that you can finish you, because you know, when you go, because I remember when we were in college, we were taught something to do with SWOT analysis, and you know, the SWOTs, you know, the analysis whereby your strength, you know, is the weakness. Yeah, somebody can rely on your weakness to be their strength, you know. So like the corruption cases that might be against the deputy president, maybe somebody has filed that, so that might be their weakness and they want to finish you that because they know your potential, you know. That is what is there. Even if you look at when you are in the business environment, you will look at the companies, and this is how I usually look at. When you look at the companies, you might be producing the same product, but what really makes you the best and make sure that in that business environment you occupy maybe about 70% of that market is you use your business intelligentsia or the market intelligence and know that, okay, we are producing the same product, but when it comes to packaging, we are doing our packaging best. The other person is not doing his packaging best. So you utilize on the packaging so that you can get more customers, or you can get your goods moving in the market. So that is something that is there. And now let's come to the cases, because there were some prayers that I think like today has been dealt with, and from the petition side, because one of the prayers they were asking was about the role of the DCJ, which you've talked about, and it has now been confirmed that DCJ can assign the panel, and that one was answered. Again, it is also confirmed that DCJ acted lawfully in that. There was also this issue of the sittings, yeah, that it was alleged, you know, and that one also was answered. What is your take on that?
I think there was even prayers about the application, and they have got a direction that the applicant should proceed to Court of Appeal to appeal their case in the concerning the process of impeachment by the Senate of the person Deputy President Gachagua. So that one has been taken care of, and also the issue of Deputy Chief Justice. It was a question of debate, and you know, by even from yesterday night, no one has given us a clear direction. That's why we have to court are there to help us in interpretation of these laws. So we're waiting for their final decision, and they have put it categorically that the Deputy Chief Justice act lawfully. That in the case of the absence of Chief Justice, and they were arguing that what if the Chief Justice has gone for a leave, and the leave also is extended to his retirement, whereby he's going for a retirement, and that retirement also extends to the leave, to an extent that you cannot discharge any duties of the judiciary, as they are looking for a new Chief Justice to be appointed and approved. So what happens? The Deputy Chief Justice then comes in and plays the role of the Chief Justice. So when the Deputy Chief Justice can assign the deputy some roles to undertake, and they were very specific on that article 165.4, that in case that there is no Chief Justice, maybe has gone for a leave to an extension of the retirement. What happened? We can't start as a country. Deputy Chief Justice will come in and appoint the judge bench to aid and determine any substantive constitutional questions, because substantive constitutional question does not arise only in the case of Rigathi Gachagua. It can arise anytime in the case of any other person. So it doesn't mean that it can only arise when the CJ is in the office. It can arise when the CJ is not in the office. So what happened? The process must go on as per the constitution in the presence of the deputy. So I think the court was very categorically on that matter.
Okay, thank you so much. And I think Gachagua has no active corruption case in court. He's just challenging the process. Yes, that is true. But remember, when you look at the charge sheet or allegation that went to the say through the motion, you know, there are cases of corruption that are there that were alleged, you know. And as I told you earlier, my friend, you know, in the contextual, we are looking at politics. Forget about the legal processes. Yeah, we are looking at now, we are coming back to the political processes in our country. You know very well that such like incidences. Somebody might just come from nowhere and start to challenge you on those and just frustrate your life or your life for no good reason. So I think by him going to all this, and maybe if court can make pronouncement and say, okay, all these were not duly done in accordance to the law, then he will be okay, because now somebody will start to initiate such like problem. If you have any corruption cases against him, it will be like, I think it will be like a fresh initiation. Like now you want to accuse him of that, but based on what the courts will rule, that one will be okay. Miguda, I want also to engage you on another prayer that was placed before the judges with the petitioner, and we are yet to go to the other side. Another one that the ruling will take place tomorrow. You heard the judge was saying, so the bench was saying, so was about the issue of recusal. Like the judges, they are not supposed to. That was one of the prayers again that were by the petitioners, and that is coming tomorrow. What do you have to say about that?
Can you be specific? Recusal? Can you come up?
The recusal of the bench, whereby the petitioner were feeling that they feel that the bench should not participate in their case, bearing, I don't know, they're talking of biasness. Remember very well that this bench that is here, first of all, was constituted by the Chief Justice in the initial stages, and the Deputy Chief Justice also affirmed this bench. And due to the fact that they feel that how the first application and how they were had prior, they feel like the bench is not suited for their sittings. So that's why they feel they should not articulate their issues.
Yeah, the applicants had several issues as the determination was made. They keep on raising several issues and several prayers to the court. The issue of requesting for the bench to be a bit fair, I think Ogola tackled it. Justice Ogola said that the very bench you are disobeying, you have disobeyed this bench, and this bench is the one which you have brought your application to. So there's no way you are bringing your application to the bench and you are disobeying it, that it is not correctly constituted, and you're also disobeying the person who has constituted this bench. But this bench has been so good to you, and they have given you a listening here, and they have accepted your application, and they have heard you. So I think the issue of that issue was well addressed by Ogola, and he was telling them that,
the one that was, among the prayers that actually, among the prayers that I might recall that the petitioner brought to the court, one of them was they brought about the constitutionality if the Chief Justice has a power or has been provided power by the Constitution to constitute a bench. That was one of the prayers. Second prayer was they were talking about the sitting, that they alleged there was a sitting that they were not informed, which those two has been answered. One of the prayers that actually is going to be decided tomorrow is about the recusal of the bench. And if you're very keen, the Professor Githu Muigai was asking the petitioner at least to bring or to provide or to bring those who or evidence for cross-examination to know why they feel that the judges should recuse themselves from the case. Yeah, so maybe because that ruling will be made tomorrow when the consolidation case and everything will be because tomorrow they're challenging the recusal. They're going to give judgment on that.
Tomorrow they are going to make a ruling to determine whether that bench was properly constituted by the Chief Justice.
Yeah.
Because if that bench was competent to handle their case. But in the argument, in the submission, there was argument that there is no way you are an applicant and you have come before the bench, and you are against accusing the bench, and you want that bench to determine whether they are competent to hear you or not to hear you. This very bench has given you a time to do your application. So applicants had problems from after the ruling was made, and they were introducing the way. That's why Professor Mugai objected that can the applicant provide evidence to prove that the very court they were not mandated as per the constitution. So as per the provision. So you get that that one it has been set aside, and we are going to get the ruling tomorrow.
Okay. Now, in the event, in the event if Chief Justice could have appointed the same bench, do you think the petitioner could have complained? In the event, because Chief Justice, if to say, okay, the CJ prior, when we were talking earlier before the judgment was made, everybody was saying, okay, you know how it happens that the Chief Justice, the Deputy Chief Justice, does not have those power to assign a bench or a panel of the bench. But now, let's just put it hypothetically, that hypothesis we are looking at, okay, the Chief Justice said, okay, because this bench had already constituted it earlier, can you continue with the same mandate? Do you think there could have been a complaint, or things could have been as usual?
Yeah, there could be simply a complaint from the applicant side, because you know, as a spectator, you expect to see a smooth progress in the court, but it can't be that way, because you know here is a context whereby applicant must have they must look at each and every possible leeway where they can actually find their way out. So those are one of the areas they are looking to find their way out. You must explore all the possible opportunity in the provision. So those are one. So there is no way they could have not make any complaint. See, they could have make any complaint. Even if this one is addressed, they still have another one to come, because this is a scenario whereby you have to. This is a war where you have to fight. You have to fight the last man. The only person who can stop this war is the determination or the decision by the court. That's the final. The decision binds all. Even after the war is made to an end, they will say that we respect the decision, but we disagree. So you see, it is something that you cannot expect it to end the way a spectator or a fan would like to see it, or the way you would like to see it, the smooth progress. That okay, just admit because you have been defeated. Admit. Just say yes. No, there's no way they can back down, because they have already committed themselves that they are going to defend their client to the latter. So that, I think those are just some of the way they're trying to find those way out. The weakest point from their opponent submissions. That's why you see you are the good guy objecting that where the evidence, and you know, even there were some submissions which were not in the court. They were in the court, but they were not been submitted to the bench. So even the guy will say, okay, there are some submissions here. They are in the court, yes, but they were never submitted to the bench. And also you have that issue of transmission, whereby how do you transmit something? And transmission, it has been interpreted in that court that transmission is now electronic, whereby because the emergence of the technology, you can submit something virtually, electronically, whether you are in that court physically or out of that court physically. And there's another thing, they introduced the issue of public participation. And they ask people that what is public participation? And they rely on the Black Law Dictionary. That is the dictionary which is being used by most of the lawyers in the common legal system. It has all the legal explanation, all the legal context. It's Black Law Dictionary. So if you go to the Black Law Dictionary and you research about public participation, it's talking about a considerate number. Now the question is, what is this considerate number? So what other person can see considerate is what I can see considerate.
Yes.
You see that the judiciary has just passed it, that okay, we have cited Black Law Dictionary and it's talking about considerate number. So it means there were that ruling was made with authorities.
Yes. And now, before we go and look at the prayers actually that were being asked by the side of the side of the parliament, the legislature. We will come to that, and it's something that actually did not go well with senior counsel Paul Muite and Bungai about playing to the public gallery. What is your take on that? Where the other councils were deciding, okay, these people are playing to public gallery, they don't want this one to go. Why are they so like that? Or it's also whipping emotion. But it is true. It is true. Me and you and the majority of Kenyans are they want to know. They want to know. Every Kenyan is that in the wanting mode. What is this that is happening? Yeah. So with them also, they want to give the Kenyan public what they want.
Playing to the gallery, in my own opinion,
yeah,
it was a distraction from the respondent.
Yeah.
Respondents were just distracting the applicants because even if they were playing to the gallery, Dansan Omari has played to the gallery outside the court when he was being interviewed by the mainstream media. He played to the gallery and he told us that this case might take 3 years. So Dansan Omari has already played to the gallery outside the court. So inside the court, I don't think Paul Muite was playing to the gallery. They were a bit serious. They were never playing to the gallery. So when that sentiments came out from the respondent, the respondents were just trying to distract the applicants because already they knew that they were making progress on their side. So when they are making progress on their side, they're just trying to distract the respondent, at the same distract the applicants. At the same time, they're trying to crack some jokes, even because you have heard Tom. Tom is saying that as a senior counsel, let me give you direction. Let me call that senior counsel. So they were happy. Inwardly, they were very happy because they were making progress. Because this case was a bit complex, and when you are making progress, you must play to the gallery. I think it is the respondent who are playing to the gallery, not the applicant. How do you play to the gallery and you are losing the case?
Okay, thank you so much. I will get back to you. Makubura Barigani.
Niko salama. Habari ya nyinyi wote
si tuko
ambao
salama
mko studio na ambao wenye wako comment section. Mimi pia ni kama nimecomment.
Hatukuona.
Okay. Yeah, so we enjoying the conversation and we like what is the analysis that you've been doing.
Yeah.
And I think it's a good thing. I'm getting to understand what really happened today.
Okay, thank you so much for the compliment.
I've commented, I think, in the private chat. So I thought I was commenting in the right place. But I'm okay. Conversation. Thank you.
Okay. Okay, sasa umesema umekuwa na siku njema?
Nimekuwa na siku njema. Nashukuru Mungu. Kwa maana mambo yote yako sawa.
Okay, asante sana. Sisi pia tunashukuru Mungu na pia tunashukuru tu Mungu kwa kutupatia nchi mzuri. Unajua mimi saa zingine huwa nakaa chini naangalia, napiga darubini kwa sana sana nchi za Afrika tuseme. Mimi naona kwamba Kenya ni hakuna nchi kama Kenya kulingana na mimi. Kitu ambacho sisi tunakosa kama Kenya ni uongozi tu, na hiyo tu. Kama uongozi wetu inaweza kuwa bora, mimi nakwambia nchi yetu itakuwa ni nchi ambaye inaweza kuwa nambari 1 duniani kwangu mimi, na ni nchi ambayo mimi nafurahia kulingana tu na vitu ambazo zinatokea. Hata saa hizi ukiangalia mambo ambayo iko mahakamani, na ukiangalia watu ambao wameenda, ambao wanashughulika na mambo haya mambo ya kikatiba, unaona. Leo katika runinga nilikuwa nasema huyu alikuja katika namna ya mtandao, kijana mwingine mdogo, ni kwa umri wake ni bado mchache kwa umri, naweza sema. Na yeye pia amejitokeza, yeye pia anataka sikilizwe. Inakwambia namna nchi yetu iko na uhuru fulani, ambapo tunaomba wale watiko katika viongozi ambao wako katika mamlakani wasitupokonye hayo kama nchi. Hiyo ndio maoni yangu.
I totally agree with you. I think Kenya is one of the best countries in the world. We are a blessed country because we have almost all the resources which are very important for the world. We have the best brains. You know, Kenya even produced the first Black American president in the whole world, something that has never happened anywhere. So that is a confirmation that this is a blessed country,
Yeah.
a country that hosts one of the, learned, blessed people. We've been having conversations here, and our friends who are also in US or in UK, like I know one of my friend here, Mato. I think from the conversations we've been having, is an engineer doing a very good work over there at the US, and is being recognized over there. But it's so unfortunate that over here, the government is giving opportunities like building of airports to foreigners. But it really doesn't make sense. We have one of the best engineers. It was confirmed here by our friend Gypsy Corner that most of the road systems in UK were actually drawn by Kenyans, and are being recognized over there. Yeah, so I think as a country we have what it takes, and if we have a good leadership, I'm quite sure that we have what it takes to be the best country in Africa.
And let
We
me just
have all the best athletes in the world.
Oh, don't mention that. Faith Kipyegon. We sasa utapata Faith Kipyegon wapi kama si Kenya.
The likes of Eliud Kipchoge,
It's in our country.
I think the leadership of this country is they're the people who have let us down. Kenya is the only, if you listen to people who are coming from Tanzania, they will tell you that just staying in Kenya is like going to university. Once you stay in Kenya, you go back to Tanzania, it's like you've gone there to study your masters, and if you go there, you will automatically survive.
Kwa Kiswahili naweza tafsiri kwamba tunaenda ugaibuni Kenya.
Namna hiyo, kwa sababu wameshinda wakituambia, na sisi pia kama Wakenya tunajivunia. Shida tu yetu ile tuko nayo ni viongozi wetu ni wale ambao hawajali maslahi ya wananchi, ni wale ambao hawatetei wananchi na wafuati maagizo zile zimewekwa na Constitution of the Republic of Kenya. What they are really doing is enriching themselves and their friends and their families, making deals on behalf of the nation, making deals which are actually not benefiting the country, but actually robbing the country. So if we can find a way of fixing the leadership of the Republic of Kenya, then we'll get out of all these difficulties that we're having. And then something else that I like about this country is the fact that, especially the young people, they are very much awake. Whenever they see anything that is not helpful to the country. The other day, the Gen Zs came out and they reminded the government that this country belongs to them and that the government has to do what is right. And you see, if you followed what happened, you saw what the president did. It has now even led to impeachment of the deputy president. And so that has confirmed to us that we are a people who are very much awake. We are people who are very observant. And all we are looking for and all we are aspiring for is to have a leadership that would make us or take us to where we want to go as a country.
Okay, thank you so much, Miguda, for sorry, I've been having Miguda on the show until now. I'm very much confused. Makobura, thank you for much for joining. We were just going through and giving our thoughts on post-analysis of what transpired in the courts and on how the judgment, some of the judgment were given on the pre-trial, because this is on the prayers. Or Miguda, how do we call it? This is a pre, right? It's a pre-hearing, not trial, a pre-hearing. Yeah, it's a pre-hearing because this is where the prayers are being discussed. Those are very relevant, are accepted. Those are not very relevant, are being dropped so that when it comes to the real hearing, we have a smooth sailing. We have a smooth running of the cases or of the process, and that is something that is quite okay. We were talking about the pride that we have in our country, and one of the things that make me proud so much is that, did you know that there was a time the M-Pesa money transaction was something that it was the researchers came and they wanted to know how M-Pesa operate, especially when it comes to mobile banking. It started in Kenya, by the way, if you don't know. The mobile banking.
We know.
You know that?
We know.
Sasa wewe unataka kuniambia Kenya ni nchi mbaya gani kama mobile banking?
It started when we were in high school and you were briefed.
Yeah, if mobile banking in the whole world, mobile banking.
The person behind Pesa mobile banking, he was by then was a young man. I don't know if now he's not a young man, but he was a young man.
Then.
By then.
Yeah.
And he was coming from Kisii region. Huh?
Yeah.
So that's why we don't want tribalism in this country. That's why we are allergic to tribalism, because he's being recognized as a Kenyan. He's not being recognized as someone from other tribe. That's why we are saying we are tribeless as Kenyans. Because if you start discussing this issue of tribalism, because why is it that during at least we are not tribe, there's no tribes, that we are saying we are celebrating Kalenjins?
Yeah.
We are celebrating Kenyans.
Yeah.
So in politics, where we draw the line, we are dividing ourselves along our tribal line, that the Luos, the Kikuyus, the Kisis, the Kambas, Atikamba, Kingpin, Luo Kingpin, Kikuyu Kingpin. Why can't we say that it is Kalenjin athletes or it is Kisis who invented the money transaction? So we just say he was a Kenyan. Yeah? We are Kenyans. Those are Kenyans. So let us embrace that patriotism into our politics, so that whenever we are playing politics, let's distinguish. Let us not have tribal. We as Kenyans, we on this ideology, we on this philosophy, we on this particular agenda, not tribalism, because that man is being given accolades after the country as a Kenyan, not as someone from another tribe.
I wanted to respond. I can see a comment here from someone called Leo TV. I think he didn't understand what I said.
Yeah.
I was very clear that I can see his writing is.
Can you drop the
link? Maybe you can share the link. Link is not. You didn't understand what I really meant. I was just trying to say that.
My side
for
is
his information.
Yeah.
Allow me to answer.
Yeah.
I can see. I think he misunderstood what I said. I was very clear. I said that Kenya is one of the best countries. We have what it takes, and we have the capability to run the nation. We have the best engineers around, and that's a fact. And what I was trying to say is that I did not singularly talk about something in a negative way. I was just trying to explain the fact that as a country we have what it takes, and it is unfortunate that the people who are specialized in such fields are not being given the opportunity. You see, for example, in Kenya, we've got one of the best engineers, but you see the roads around, they're being built by people who are foreigners. And that is something that we need to look at as a country, because we are not giving, an environment for people who have this knowledge to also expand. But you see, some people who are engineers, for example, if they get out of this country, they go somewhere else, they're being recognized and their effort is being rewarded well. So what I'm trying to say, let our good friend, Leo TV, he needs to, I think he didn't understand what I meant. Unless he has something else, we can share the link, he comes in.
Okay, because like I'm
what I was saying.
I'm trying to share it on my side. Is not. I don't know what's wrong with my laptop.
Maybe I try on my side.
Yeah, he's saying the airport issue is not about labor, it's capital. Adani is not importing labor, it is
Let him just come and say what he is.
Share so that
Even
we
if you have time.
Yeah. Okay. As we still wait for Leo to come in, I know Leo. We've had Leo in one of.
I also know Leo. I
Yeah.
also know Leo.
In our sister channel, so I know him. He's
Yeah.
a good brother. He's one from our sister channel. Yeah.
Acha kunipiga hivyo vile anipiga. Kinini, acha ingia hapa tuambie.
Okay, thank you so much, Makobura, for coming in. And we were just talking before. I'm seeing wacha leo aingie tuongee kidogo ndio we can end the show so that we wait for the second session of the show that usually comes in at 10 with Makobura and Miguda, Barak, Kiplimo, and so many of us will be there in the second show. Hopefully, it's going to be quite much. Okay, Leo, kindly please, we are waiting for you so you can come and Makubura, on assessment. I don't know whether today you had an opportunity to even to interact with what was taking place. Maybe your view or your comment based on the entire scenario that transpired today at the courts.
Okay, thanks so much. My opinion for what really transpired today is
there you go. Hello,
yes, let's invite
him.
Yes, brother Ben, how are you?
I'm good. Long time not seeing you. Kwani uliamua wewe hata uonekani?
No, Nico, I've just been having some engagements here and there. Even right now, I'm sorry, I was just in a place getting some, there's something in Ethiopia.
Oh, okay.
And they call it Buna. Buna is some special tradition of coffee. So as you can see, I'm in a shop with Ethiopia and Kibanda getting that coffee. But I just wanted to make something clear.
Okay, go ahead.
I like his program because I like how he's really good at it. But I have a feeling that there is a way our people are being like misled to buy some populist politics by politicians who want to maybe become famous and make their name out of something serious. People speak about this Adani thing. They'll tell you that, okay, they've really been getting misinformed. And I personally, I only had one problem with the Adani deal. The problem is that everything ought to have been put in the public so that the public should have known the companies that bidded alongside Adani and what made the government or maybe the department to choose on Adani over other companies that bidded. So the issue that we're having, Ben, I know you've traveled outside Africa and you've been to some of these airports that are maybe considered the best airports. I myself, at some point, I've got an opportunity. I've traveled to some African countries, some Asian countries, and you realize that if you look at the airport that we're having and you compare to what our peers are having in their countries, they're way ahead of us. What we need in our airport, Nairobi and Kenya is a powerhouse, not only in Eastern Africa, but in Africa. If you go outside there and you say you come from Kenya, some of them know that Kenya is the capital of Africa. So if you look at our airport, things that are leaking, this airport has always been managed by the Kenya Airport Authority ever since I was young. But we rarely get the report that they're making profits. What we've been hearing is that this company, this parastatal has been making losses, and the government bailing it out using the taxpayers' money. Number one, being a parastatal, they don't pay any tax. They should be creating employment and giving people some better services, not only in Kenya but across the entire continent. But they don't do that. They make losses, and because it is a government parastatal, the government will take our taxpayers' money from other departments that are doing well.
then pumped there, then it gets drained. So it has become a corruption a conduit where specific people benefit themselves. If you look around the world, even if you look at our neighboring countries, Rwanda, go to countries like currently the Ethiopian Airways is rated the best in Eastern Africa. If you look at the rating, and they're not way ahead of us. Even in terms of their cost, if you fly Ethiopian Airways and you fly our Kenyan Airways, you're likely to pay cheaper in Ethiopian Airways. So what is happening is these organizations are not making, these companies, these parastatals are not making profit, but we can be able to lease it for a period of only 30 years to a private company to come and run it. This company is going to make the profit, of course the profit belongs to them. How are we going to benefit as Kenyans? They're going to create jobs. More jobs are going to be created because if the services are good, those people who've been flying Ethiopian Airlines and some got an extra flying Turkish Airlines from Kenya to African countries. They'll now be using they'll be using our airports and our facilities. They'll be using our hotels. So most people are going to get employed. Number two, they're going to pay the government taxes. And number three, they are going to expand this airport at their own cost, hoping to recover this money within 30 years. So if they don't recover the money in 30 years, that is up to them. After 30 years, we are going to retain and own the whole facility. So are we benefiting or we are going at a loss?
Okay, there are some issues. Okay, there's questions that I want to engage you on, especially when it comes to Adani. And we want to disagree with you on one of the issues. No any other Kenyan, I feel, disagree that our airport need upgrading. Because as per the standard of the world, the world we have today, for you to have that hub and especially connection, especially with where Kenya is strategically placed, especially when it comes to connectivity. So by us upgrading our airport, that is something that no any other Kenya is disputing. But from where I think, and those who have engaged with, what Kenyans are disputing, Kenya are disputing the process. That is one. That is one of them. Secondly, Kenyans are disputing why Adani, and we know very well that there are some issues or questions of integrity that is being raised about this country. I mean, this company, and also Kenya are some of the things that Kenya are disputing about the 30 years. And you look at the 30 years, after the 30 years, they are still going to get some percentage out of it, So what is being disputed is the integrity or the face of that company. And if you look at the benefit that Kenya is going to gain with that of the Adani, there's nobody, I feel nobody is disputing, because even before Adani, it's not the first time that the upgrade of Kenya airport is talked about. Remember in the Uhuru time, there was it as a Greenspan that was supposed to upgrade the airport, and the project did not kick off.
So that is why I'm telling you, during the Uhuru's time, the government spent a lot of money in the upgrade. If you look at Terminal 1A, I think I used it before, but by the time they were upgrading it around 2020. But barely a year, you saw what was happening. The roofs were leaking, meaning the money was allocated, but somebody did some shoddy work. So when you put it into private, it has proved to all Kenyans that private entities are run better than government entities. There is a soft spot in terms of government entity, whereby today, if you're working for government and you're working in a private institution, those who work in private institution, number one, will always keep time, because they know there are some consequences. But those people working in government, go to government institutions, look at how even people report to work. They just do it knowing that, okay, it is permanent and pension and that kind of thing. So there are some things that we need to look at. I get the issue you're talking of integrity issues, but I think there are better ways of dealing with integrity issues. But what pains me is when you get outside there, somebody saying that airport is being sold. So there's nobody who's gone out there to tell them the difference between leasing and selling. I come from Siaya. There was a certain company called Dominion. I think the American company that invested there, and they are doing some rice, and in the process they decided to divert. Instead of doing what they agreed in the lease, they diverted and started doing some other crops. I think that will cause some disagreement they went away, they went to try their luck in Nigeria and such kind of things. You know about that story. And when those people left, people who are really benefiting directly and indirectly are the ones who really complained. The politicians and other people never complained because they didn't feel that impact directly. So the same with these Adani.
Let me ask you from yeah.
So that when they speak there, right now, my grandmother in the village, what my MCA will go there, will tell them, Ruto anataka kuuza Adani. So that is what sticks in her mind. She knows that it is going to be solved, and that is the end of it.
So
I think, Mr. Ben, maybe
let me engage with then you can come in. Let me just engage, ask him a question, then he will. So from the entire thing that you've said concerning Adani and even the Dominion, that at some point there was a valuation that I was involved when the Dominion was taking place, when I was working with another company of the valuation of what we call it, the valuation machinery valuation. I was involved. So if a member of parliament, somebody that has been given the power that should actually give correct information to the public so that the public could know, they're not doing that. Because now, how do we blame even your grandmother who is being told that the airport is being sold by somebody who is in the leadership, who should give the correct information? That is how I want you to answer me. So we see where the problem is. Is the problem with the Kenyan people or the problem is with the leadership?
I think the problem is with the elected leadership. They failed in their representation. They're the ones who are supposed to give the right feedback to the electorate so that the people that they elected will now be able maybe to send them correctly. But if they start by giving some political sentiments and misinformation, then the people on the ground will also buy this kind of propaganda. Then now comes the experts and the media who should now disseminate this kind of lies and tell the people the truth. Because people now lost faith in their elected leaders. So it is only the fourth state that has remained to go and advise these people. But if you look at the media, they also welcome activists. And activists, obviously, they're always against politicians. So when you see politicians who are also supporting this and anything, they don't understand it, they cannot explain it better, they just say we support it, not giving any explanation. So the activists that you see out there, people like Morara, are now taking advantage so that they can be able to get some sympathy and political mileage. But there's something that people need to know. All these activists that you see, they normally mutate and become politicians. Every politician that you see today was once an activist. Look at people like Jim Orengo. Look at all these politicians that you see there. They started as an activist. So when you see activists like Morara and they say that this is salvation that has come, there is no salvation. These are people who are in the process of becoming politicians. So we should treat them as younger politicians, that when we don't show them right now that what they're doing is wrong, we don't correct them, they'll grow up to be monsters worse than the ones we see today.
Okay, thank you. Makobura, you can ask your question now.
Okay, first to Leo Nyabaya. It is good that you've come in. And I can see you are really speaking with a lot of energy concerning this Adani deal. For your information, personally, I was not talking about Adani. And I also want to put it clear that the people of Kenya, the Constitution of the Republic of Kenya is very clear. Anything that is being done in this republic, the people should be involved. The people has a right to know what is happening in their country. You can't tell me that with all the knowledge I have and all the internet I have, I cannot be begging for the information of what is happening in my country. They are responsible people who should be telling us what is happening in our country. This Adani thing, how many times have we seen members, people who are responsible going to the parliament and they cannot even give factual statement. They cannot even give information it can help the people of Kenya. They keep giving conflicting information. And the question is, for what reason? Why are they hiding? If they were going to either get into these conversations or deals with Adani, what does the Constitution say? We are the people of Kenya. We need to know the deal that they got into, No one has come to clearly clarify that. So as a people, if we are having any negativity towards the Dan, it is not our problem. It is a failed government. And even if my father was the cabinet secretary, who maybe would have gone to make that deal, I would still tell him that they have the people of Kenya have a right to know what is happening in their country, and it is not our problem that we don't have all the required facts about it. So it is them who should come and tell us. We know the airport has problems here, but why did they single out one company? There was no bidding. There is no any competition. Which there was nothing. Just one company came and they were given a tender. What are the interest of those who gave them the tender? Why are they not disclosing whatever is contained in those procurement deals and whatever? So as much as you're protecting or either supporting, no one is really going against it. But what we are saying is, let us be factual. Let us be people who love this country. When we say we love this country, we need to come up and say no to anything that is not clear. We as a people, we have the right. And that's if tukinyamaza hapa sahi, very soon utasikia ati ndio hiyo dealing, yani people, there was a lot of money utapata iliibo, ama there are people walipata pesa without the knowledge, without the people of Kenya knowing. So it is not our problem. What we are doing as a citizen, we are just concerned people, and it is our role. The members of parliament have failed.
There's one thing that is happening that we don't know. The
Allow me
framers
to
of our
complete and then you
constitution,
come in.
I think the
Just
framers
1
of our
minute.
constitution erred. Okay.
Yeah, so the members of parliament have certainly failed. They have not followed what the constitution say. They swore to protect this constitution, and they're not doing that. I've heard you mention the likes of Morara. I'm not supporting either of them, but what I'm saying is, if Morara goes to either your constituency, you've said you're coming from Siaya. If Morara goes to Siaya, then said that there's a project which was launched here, and it has not been. There's nothing that has happened over here. What is wrong with that? If your member of parliament has failed to remind the government that there's something you started here and you've not completed. So I don't really see any problem with activists or any concerned Kenyan coming out to voice or to remind the people in leadership that they have a role to play. That's my take. Leo, can you hear me?
I can hear you. You can hear me. No, there's something that, okay, I don't want to respond on the Morara issue. Maybe I'll just pass on it slightly. There's something that the framers of our constitution might have omitted. They didn't foresee a situation whereby we are going to be having Kenyans who will have to wait for people to go and give them information. I think when they were framing the constitution, they thought that everybody will be at a position to get the right information, either electronically or such kind of things. Like right now, there's been a call for proposals or a call for some public participation on the proposal to extend the term limit of the president so that we can have a president serving for one term of 7 years as opposed to 2 terms of 5 years each. And it has been gazetted. The Constitution talks of gazetting it in the main newspaper, that kind of thing. So that has happened. It's almost expiring. I don't know if it's Friday, which is in the next 2 days. They will find that Kenyans will say that public participation was not done. If you look at the threshold of that public participation, I think that one needs to be defined in our law. For example, in a public participation, we'll only look at, was it advertised? Yes, we advertised it, nation, success, blah, 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 blah. Did you have a venue where people had to attend? Yes, we had a venue. Did you have minutes of meeting? Yes, we had minutes. So maybe 100 people went who are pro that thing. Yeah, that one is enough to prove that public participation took place. So in that case, I think our legislators have failed in ensuring that they work on the threshold of the public participation and also to ensure that they expand it to an extent that it should be a responsibility of the MCAs or the members of parliament to go and do some civic education. Remember, you used to have civic education. Nowadays, even in school, it is no longer there. Then when it comes to Momorara, I'm not against him, but remember, you've been walking through there's a school in your village. This school has never been completed. You see it every day. You know about it. It is not a secret. You have people who've been going, the media and whatever covering it. So somebody coming to remind you that there is a school that is incomplete without giving you solution, without even taking action against the people who maybe mismanage those funds, is not helping you. This person is just igniting your emotions. And that is why majority of Kenyans voted William Ruto. William Ruto came and reminded you that you see you are a poor, you are a hustler, you don't have food, and this kind of things. And the people fell on that. The emotions became high, and they thought, oh, this person knows our problem. So the problem of Kenya is that we know these problems. We know there is corruption. We know the roads that are not complete. We don't need people like Morara to remind us. We need people who are going to act. For example, right now, we know that it is dirty. I like what that environment is doing. I'm forgetting the name. That gentleman, he's walking and telling them this place is dirty. We don't need it to do this and that. So those are the people we need to celebrate. But then people coming to remind me that road from Sori to Ndewa was awarded, I don't know, 200 million, and this is where it has reached. We know it. People Sori know that problem. So what is he doing about it? That is the question that we should be asking. We should not be excited for things that are not even making any sense.
Okay, I've heard you, but I'm disagreeing with some of your statements, and this is but the Benson here media. Here we say that your opinion counts. Partly, I believe that it is a responsibility of every citizen to come up and to remind the people in leadership that, especially when they are not doing what is right, it is right for every Kenyan citizen to tell the leaders in their eye. It is right for Morara and any activist who is willing to go through the country using their resources to remind the people of Kenya that this government did this and they've not cleared it. It is a right of every Kenyan citizen to move wherever they want to move, so long as they're not inciting anyone. What Morara is doing, I'm not supporting him personally. I'm not his follower, but what I'm saying is activism. We have to get the spirit of activism in every Kenyan citizen. That is when we are going to do away with corruption. That is where we are going to do away with all political class. These people who are misusing power. These people who are trying to use power to do what? To get into corrupt dealings, to get into deals like this Adani one without telling the people of Kenya. It is a right of every Kenyan citizen to do what they want in this country, so long as they are fighting for their country in a peaceful manner. I like what the Gen Z did. And from your conversation or from your view, it is like you're trying to say that what the Gen Zs did was wrong. But I want to tell you one thing. If we are going to change this nation, kila mtu, without fear or favor, we have to come out and defend this country. Defending this country means speaking into the eye of this political class and reminding them that they have a role to play. If they fail to play the role, then anyone, whether you are from which part of the country, you have a right to come up and tell them that what they are doing is wrong.
Maybe as you pass on, maybe to the next, I can see Dan is there. There's somebody Godfrey. Is it Godfrey or somebody Kenyoru? Kenyoru is saying that Morara is doing what the members of parliament are unable to do. Let me remind him, in the community where I come from, in all communities, what Morara is doing in our community, we call it Kalongo Longo. Kalongo Longo, whereby your mom, maybe you feel that your mom should be cooking for you some fish or maybe some chapati or something like that, and they're not doing it. So you go light some kalongolongo fire somewhere, you use some soil to cook food. At the end of the day, it will not turn into food. So that is all I can tell him.
Thank you so much, Mr. Leo. So let me just ask you in your own view, based on the circumstances and the state of the nation right now, coming from Adani to impeachment to what we are seeing the parliamentarians, the legislative arm of the government is doing, and the executive, everything in your nutshell, do you feel, and including all those that even the Morara is doing as a nation, in your own perspective, what do you take on the state of the nation?
Thank you so much, Ben. I think right now our country is in a political turmoil. If you look around, maybe we have countries like Somaliland are going to election the next month on 12th. But if you walk around, I walked around there last week, you'll find that it is not as politically heated as it is in Kenya. Americans have already started voting by mail, and but the voting is will be proceeding. But if you around there, you won't see things maybe happening the way it's happening in Kenya. But what I can say is that the happenings that are happening, like the impeachment of the deputy president, the political process. Forgive the background sound. It's political process that if not sorted now, it might come out to something else that will consume us politically when we need to settle. So the earlier we sort it now and settle as a country, the better. I want to echo the words of the Nakuru Senator, Tabitha Karanja, who proposed that we need to have, she tried to use the Moi kind of vice president, which she didn't mean dictatorship, but we need to have a situation whereby as a president, you should be working with a deputy president whom you appoint. Why do you need to appoint somebody who can be loyal to you? You need somebody who subscribes into your dreams. Because at the end of the 5 years, Kenyans are going to judge you on what you do. We don't want a situation whereby after 5 years, the deputy president is having a different view from the president. It means when the president is doing A, the deputy president is. So there's no single day we are going to achieve much with the divided opinion. So the president and the deputy president as a system must be having one goal. So the moment the goals shift, we don't want to see own goals. Own goals is what led to what we saw when the deputy president, his current president, Ruto was working with Uhuru. Game and I think right now, let him not do a mistake of getting somebody who will have a divergent opinion, so that when we'll be judging him after 5 years, we'll tell him, Mr. President and your assistant, you promised to do this. Why didn't you do it? Then on the Morara issue, it's also good. We need to have an active.
Oh, sorry, you're
and if you look at how our constitution is to be blamed, our constitution is to be blamed. In the previous constitution, we had opposition whose main role was to oppose the government, and legally, not in bad faith, but to oppose the government on things that they are doing wrong. But currently, we are having majority and minority, so we don't have opposition. If ODM feels that the interest that Kenya Kwanza is serving serves them best, then they'll join them and form a super majority, and that is what is killing us. We need to get back and see a way whereby we can have an opposition, or what we call the people's watchman or something like that. So people like Morara at liberty to oppose the government. So my only fear is that they don't have any constitutional avenue to do that. So however much they try to oppose, you try to demonstrate, it gets ruled unconstitutional. So we're having a powerful constitution that somebody will even take your life and use the constitutional provisions and deny you your rights. So that is the only problem we are having. But politically, if we can, the president can put his house in order, I think the earlier the better.
Okay, thank you. I want to engage you also on two other issues. Makobura and Miguda, you'll bear me some time, please. I beg you. I want to engage Leo on two issues. He talked about the deputy president, whereby somebody should actually appoint somebody who share the view. And I want you to look at it in this perspective and give me an answer, because you know how the political structure or the political terrain of Kenya is that when a political party or when people are going to election, they come together. And the positions are given in the basis of your tribal, based on the numbers, not of your qualification. How can we cure that? Because that is what has cost us what we are today. Because the positions that have been given, and everybody from the presidency to the position that you have is based on the numbers that you're bringing during the election. You can also talk about, you talk about opposition, that we should create that. And when you look at our constitution, I think they envisaged enough that everybody or all Kenyans in the leadership, they will have fidelity to the constitution and adhere to what the constitution say. As we speak today, the minority, because we have a parliamentary system, and in the parliamentary kind of system, it is to checkmate the executive. So it means that if there's an issue with the executive, it doesn't matter where you belong. You have to put on, because like you are practicing the fidelity to the constitution, because that is where you are, you know. And I'm bringing you to the issue where it was borrowed so much, 100%. It is borrowed in the American Constitution. You're getting me? Yeah? The American Constitution, they do not have.
I'm getting you.
Yep.
Can you hear me?
Yes, I can hear you. Yeah. On the issue of, yeah, I can hear you very well.
Right. I think on the issue that you played,
yeah,
that is good. Our constitution having the parliamentary system, and remember in the parliamentary system, these members of parliament are also part of the executive in that their coalition is the one that is having the president. I think this one, they would have made it better if we had a system whereby after the election, then the members of parliament or members of senate sit down and elect an executive president. So in this case, the number of numbers and the number of my community of the voters, because our political identity up to date and maybe in the near future is still ethnicity. So there's no way somebody will say, we people of Mount Kenya, we people of you, our person. This person is elected equally by the members of parliament, whereby if I have an MP from Turkana who is representing 1,000 people, will have an equal right, the same as an MP from Embakasi, he is representing 100 people, 100K people to elect a president. So that one is what will solve this issue. But right now, you are having a president whereby during campaign, he campaigned for these members of parliament, then have to remain loyal to him. That is the problem that we're having when you look at how our maybe parliament is structured. So, like, we cannot have an independent parliament. This parliament, most of them, maybe they're members of Kenya Kwanza, they had a manifesto and they have to support every bill that their leader, who is the president, wants to pass, because they will base on this when it comes to next election. So the system of government.
So in your view, yeah, okay. In your view,
I don't know if you
yeah, I'm asking you the second question. In your view, the way now you argue, yeah, where is the problem? Is the problem with the how the constitution was done, or the problem is with the leadership that we have? If the problem is with the leadership, then how will bringing member of opposition cure those character traits that they are practicing? And if the problem with the constitution, how again will they cure all that what we are going through?
Thank you. I forgot to respond to the issue of the vice president. There was a point after Kibaki took power, there was some agreements, and remember Kijana Wamala became the VP when he passed. Kijana Wamala was coming from Anakia, and they expected that the same party of Kijana Wamala is going to produce the next person who will become the VP to replace Kijana Wamala. But Kibaki shockingly realized that the people in that party were not going to be loyal to him and to help him achieve his dream. He went and did the unthinkable by appointing Mudia Wori. Mudia Wori was in the Raila's MVP. People did not expect that one to happen. So that one also explained what maybe you saw the president doing recently. So it has happened. Look at Kibaki in his second term after the post-election violence. Why was he able to work confidentially? He had somebody like Kalonzo, who not even a single day disagreed with him. They had an agreement and they worked smoothly. Why is it that when we had Uhuru and Ruto, we started seeing this kind of things happening? Here's a situation whereby Ruto wanted to become president. He wanted to serve his interest, and Uhuru also wanted to serve his interest, so maybe leaving a legacy. So at the end of the day, you find that these people are not working together. So if we can have a situation whereby after you've been elected a president, you now appoint somebody a vice president, somebody that you can fire anytime that you feel that your views are not aligned, like somebody who will claim that, I was elected by 7.2 million people, there's nothing you can do for me. If we say we are going to build hospitals, and I feel that I don't want hospitals, we want build schools because everybody is serving their own interest, that is it, because I was elected by 7.2 million people. You need somebody who is your assistant. When appointing your assistant, you need to appoint somebody who will tow your life. So when you fail together. When President Uhuru Kenyatta failed, Ruto excused himself and said that those failures are not mine. Isn't it Kenyatta? So the problem that we're having is that we're having an advanced constitution that we are not yet matured to. If you go to places like America where you are, the constitution serves you right. America is a country that doesn't have ethnic identity. It's an immigrant country whereby people don't talk of their ethnic groups. But here we are having a country whereby our main voting identity is our ethnicity. Right now, how many people are supporting Gachagua? The very people who used to abuse him every day are the very people I saw representing him in court, including that Njiru, that Wakili. These are the very people who used to mock him every day. But why are they representing him? Why are they defending him? Because the Mutuetu. So with our Mutuetu ideology, this constitution only serves best in a mature democracy. Kenya is not yet a mature democracy. We still need to mature up is when we can adopt the constitution. I know the parliament has got the power to change this constitution. Why do we have wrong leaders? We have leaders who are elected based on the ability to manage CDF. Forgetting that among the responsibilities of MPs is not, none of them is to manage the CDF. Their responsibility is to make laws, to oversight, and to represent us. Why are they not oversighting things that people are complaining here? Because they know very well, if I manage CDF very well, people will elect me to an extent that you have MPs who cannot even bring a bill in parliament. They'll tell you that their dummy deal is wrong, yet they can ask to go and discuss this in parliament because they don't know the process. You just have comedians there, people like Salasi, I'm sorry to say that, they'll come and talk in the funerals, they'll make TikTok videos, so whenever they want to talk in parliament, they become activists within a parliament. Today I was shocked to see Kaluma saying that CBC is bad because we don't have infrastructure, it will revert back to 844. And if I checked, Kaluma is having, I think, his second term. When CBC was being introduced, he was in the same house. He participated. He did not contribute on this. Then he goes on Twitter to type this for people to clap for him. Yet he's an elected member of parliament. What will Benson do? What will my brother here do? If an MP which will be doing this thing, he sits where he can summon the Minister of Education and all these kind of people, goes on Twitter to tell us how these things are on. So our priority, we need to tell our people that when you're electing an MP, you don't elect this person to come and help you in funeral. You don't elect this person to come and pay your hospital bill. You elect this person to go and make laws to ensure that when you are sick, you get treated, and the medicine is supplied in the hospital to make it a criminal offense for the maybe managers of these hospitals to mismanage the resources over there. But we elect MPs who wait for us to have problems. They come with the money, then we say so and so is working kwa sababu alileta basi shule.
Okay. Thank you so much. I would prefer, it's just like our time is out, and I would prefer to engage you on an issue here. One of the issue is about, you've talked about the issue of tribalism, and you've compared it to the United States, whereby you say the United States does not have tribes. But let me tell you, when you are talking about the United States, the context is quite much different with Kenya, because as you talk about it's a country of immigrants. One thing that you forget, there's also one factor that usually plays part in United States, that this is called the race. Those are some of the things that you have to look at. So as much as we are saying that it doesn't have the tribalism connotation in it, but there are some other factors that affect that we do not have. In us, we have tribes, but when you come over this, in most of these areas, people talk about of race or people of color. And that is a very, very big issue. And you find during the election, it becomes pertinent, an issue in terms of voting. I hope and I believe you remember when there was an interview that was organized whereby the former president Donald Trump, when he was in the interview and he was asked about the deputy president, the vice president, and I quote, this is what he say, that all along I knew she was an Indian, but now she has changed to what? So you find that when we are looking into that, we should not compare it in terms of like the tribe, because the factors are quite much different. With us, we are built on a tribal. We are tribes, tribes in our country, and here people talk about race and so many other things. So I think the bottom line is, it's not about race or it's not about the constitution. The bottom line is, it's about the leadership, on how even the politics is being done. And I tell you for a fact, let's just agree, even in the Azimio, when Her Excellency Martha Karua was elected or was appointed to deputize the Right Honorable Prime Minister Raila Odinga, we knew very well that the ideologies doesn't match, because Martha Karua usually has a stand. But the main thing on the card of her re-election, even to come from Mount Kenya, was the issue of the votes. That was the first thing that we have to agree. So we have to be very factual when we are talking about the leadership. When we are giving somebody the deputy president, it's not about sharing the ideology. It is about, first of all, we give you this position based on the area where you are coming from. If you are very truthful to ourselves, even today, the president could have nominated somebody from Ogiek family who has qualified, because they are the minority and they are Kenyans. Why was it that he had to nominate from that area? Just because he's looking at the potentiality in terms of the both and the regionalism. So if we were saying that because Gachagua was there because of tribalism, that he was propagating that we don't support. But in the spirit of Kenyaism, why was it so difficult for the president to bring somebody from Ogiek or from a minority community? We have people from Turkana, we have people from Isiolo, so that we could see the spiritualism or the spirit of Kenyaism in him, in the political field. That's what I think.
I get you, Ben. First of all, allow me to say hello to Maureen. I once worked with her, at one of the greatest collections, Jade collection. Those are people I interacted with. And sometimes when I speak of Kisumu, I've been to the major cities within Kenya, and I understand their dynamics. Just to respond to your issue of regarding Gachagua, and I've told you the type of the constitution that we have that advocates for parliamentary system, and it's not fully parliamentary system. It's a mixture of parliamentary and a presidential system. And the framers of our constitution, I think, if you look at the Bomas draft and what led to the 2010 constitution, there are some disagreements when they had to choose between the parliamentary system and the presidential system. Remember, there was the Kibaki side and the Raila side. And one of the promises that was there during the 2008 National Accord that was witnessed by Kofi Annan was that was one of the things that was supposed to be done was that the Kenya was supposed to get a constitution. This is after the 2005 constitution was aborted. That one that was voted no. So Kibaki and Raila had to honor this, and they had to ensure that they give Kenyans a new constitution. So they had to seed the ground. Those people who wanted presidential system and the ones who wanted the parliamentary system had to come into a level ground so that they can agree on a mixture. That is how we came up with a confused system. And in this manner, the president is nominating a deputy president when he is having the votes in mind, knowing that this is my running mate, and if I appoint this person, the person is going to give me more votes. But imagine a situation whereby a president is elected by the elected members of parliament, the 290 members, irrespective of the numbers that they have behind them. Today, Kimani Ichung'wah will come and tell an MP from Mandela that I have more votes than you. So my point will be listened before. You had my very own Senator Sifuna bragging that, I
Yes.
represent over 700K, which is the majority. So when I speak, I need to be listened to because I represent numbers. So that thing will not count. This kind of numbers will not count. So the problem that we have is the tyranny of numbers. So the moment we'll deal with this case of tyranny of numbers, whereby the numbers only play when electing your MP, but when it comes to electing the president, the numbers doesn't play, then the members, the 290 selected people, can be able to get an intelligent person from minority to be a president. And like when you leave this one, I tell people that don't be surprised. There's some words I can't use, but majority in a democracy, majority have got their way. So maybe if you have majority who are disabled, the chances of having a president who is disabled is higher because majority will have to go to their own. If you have a majority who are fully, sorry for using that word, then we can have a fool becoming a president because when you have many fools together, they'll elect one of their own. So we are having people who are tribal based, like Gachagua, in the position of a deputy president because of democracy. Gachagua will be elected even in 2027 if he appears on the ballot because his tribe, whom he commands, have the majority. So you can't stop them. The only thing that can stop that, the Mount Kenya and the challenging dominance that people keep on crying of, is not impeaching Gachagua. But looking into our constitution, whereby we can have a college of people electing a president, whereby the college of people, if we have one person representing me from Bulgaria, another one from any other place, at least they can be able to reason. And like when you collect 1,000 or tens of thousands of us in the same room.
Okay. Leo, I agree with you on that proposal, and that one would work, especially the South Africa system way. That one would work, and will get us out of what we have. But right now, we have to be very factual and agree when we want to talk about the good leadership. Even talking about all these, the tribal, as you said, impeaching Gachagua, that one is not going to stop this one from happening. It will come in another way, that with a different name. It will not be an impeachment, but it will come with another way that we do not know, because like in politics, everything is possible. Let me take this opportunity to engage my brother before we close the show. But Nyabaya, we need to get a time to discuss, because here we discuss about issues.
I think let us get a time to discuss because
yes.
Issue of impeachment of Gachagua, it's more political that we
because like at some times we need
might
to
see be becoming a hero.
Yeah.
There's some of the plans that people might undermine him and say how he's losing Mount Kenya. I can tell you, President William Ruto is managing to attain what is called absolute power, and he's really a good student of the Green 48 laws of power. And at the end of the day, 2027, I don't think there's anybody who is going to beat him.
Okay, thank you so much. And let me take this opportunity to thank Morena War for joining us through Facebook. We really, really appreciate you. And may God bless you there in Kisumu City, the good county of Professor Anyang' Nyong'o. Hey, Makobura.
Yes, I can now realign my thoughts with Brother Leo here. While he was speaking about Adani, he was speaking like he had been sent by, I don't know whether he's coming from, which place is that? You're coming from which constituency in Siaya?
I come from the only constituency that proves to people that Raila doesn't force leaders on them. He tells people that those are the normal stories and myths. I come from Uganda constituency. My member of parliament is David Ochieng. He was not elected on ODM. So when somebody comes to tell you that, okay, Raila Odinga imposes leaders on ODM, that is a lie. In Uganda, we prove that people elect the ones they want. And if you see anybody elected in ODM, it is not because of Raila Odinga, it is the people who voted, because Raila is not a voter in Uganda.
I think we need to investigate you at the rate at which the power and the okay, we understand. Anyway, we understand that we're in a government that is they call it broad-based. Personally, I've not seen the broad-based thing. From my understanding of Kezungu, I'm not seeing any broad-based there at all. Maybe Mr. Leo, we unaona something like broad-based kwa hii serikali? Nyinyi mko ndani?
Yeah, there's broad-based. Broad-based means broad-based is like whether you have a bread. You know, bread. It is one loaf. It can be shared into tenths and some decimals, and everybody can get a part. So I can feel there's a broad-based because for the first time, if you go to our parliament, you don't have that tyranny of number. We have a situation whereby somebody can just vote based on their consciousness. Number two, we are having some of the people who are told that they're not part of the government. They've been allowed to become, of course, we've all been part of government, and the people from Nyanza and wherever been part of government by being members of parliament, which is an arm of government. But there's always been an arm of government called the executive, which has always been a reserve to majority who voted for the president, the presidential candidate who wins the election. So for the first time, we are seeing a situation whereby the minority, the people who do not vote for the president, being part of the executive, not part of government, but part of the executive. So the main fact that somebody from Ben's place, Homa Bay, was made in cabinet of treasury. So now it is upon the people of Homa Bay to make good use of that, ensure that when Badi comes back home, you milk all the money that is carried from treasury. Those people of Ugunja, we are neighboring Ugunja, of course, greater Ugunja. We should ensure that we petition for
my brother Leo.
Yes.
My brother Leo. There's a politician who is coming from your place. Anaitwa Makamu wa Makamu.
No,
Makamu is not a politician. We have politicians and we have MC. He's an MC.
We call him a political surrogate or something.
I usually name him political surrogate. He knows what he does. He's best at his work.
You can see from the comments of my brother Leo here. Leo is saying the exact thing that Makamu has been saying, because Makamu said that if one day gets there, then the Luo people are not going to pay for power. If the treasury is just got there, it's going to pay.
Have you ever attended a funeral? Nowadays, the Luo funerals are never organized the way they used to be when the family will prepare food. Nowadays, there are these people called beggars of the catering. They only give you 2 pieces, but then you may pitch and you hakuna kurudia. So if you go to this kind of funerals or this kind of venues, and you happen to find your mom or somebody you know in the kitchen, then you tapakuliwa ni tofauti. Manake when you start shouting and such kind of things, if today somebody comes from Ugunja and says that hakuna stima hapa, the rate at which Wandai will act kujaribu kufunika ndio wasiseme angalia ni minister of energy na kwake hakuna stima. It comes with a difference.
That's psychopathy. In the comments.
But listen, despite the fact that we have a constitution that these people should serve Kenyans together, there is a political goodwill. It is a fact that when Kibicho was a PS, he did a lot in his county than even the governor. There are some things we call privileges. It is not being corrupt, it is not being tribalist or maybe favoring other regions, but there are some things called privileges. Wakipika na sufuria yenu mkirudishiwa sufuria lazima kutabakia chakula. So you have to enjoy more than wale wenye kupeana sufuria.
Okay, sawa. Asante. Makobura, because I think
we should one day find time and converse with Mr. Leo.
We need to host because there are some things that some comments that I don't agree with, but Leo is a good friend of mine. There are things that are debatable in terms of politics, because there's something that I also agree with him in terms of if there are those benefits that usually come when you're appointed as a member of the cabinet, and that is political, and that one now make me to peg my reasoning on 2 things about Rigathi Gachagua. Despite the fact that he was a deputy president, there's some benefits that he felt like being a deputy president could come to Mount Kenya, and that's why maybe he was talking of the political shares. I don't know, but that is just politics. So Makobura, I don't know whether you are coming with a show tonight, or
Maybe we should talk behind the scene, and then we'll make that decision. We'll let our people know, of course. For those of our viewers who have not subscribed, I think we encourage you to subscribe and hit the button so that whenever we are having a show, you'll be utaambiwa 30 minutes to the show. So kindly, for those who have not subscribed, we are inviting you to be part of Brother Benson Media.
Okay, thank you so much, Makubura, my co-host. And I want to take also this chance to thank my good friend, Leo Nyabaya. So Leo Nyabaya has a channel who does, his channel is also doing the same thing that we are doing. One thing that you don't know, that we've come from far, me and Leo, we were somewhere, we were giving our opinions. Then from there, we decided to open more spaces for where we can discuss. So you can also visit Leo Nyabaya TV, is there. You can subscribe and you will meet us there too. We go there and discuss about issues. And it's also part of Africa 24. We have Sound Candid. So it is all about, we call it the digital bunge la wananchi. This is the one that has gone digital, and we are trying to make it more professional. And we discuss politics. The same time, we tend to create awareness on how we can have a good country. Because I usually insist, when your country thrives, you will also thrive. If your country is thriving, today if Kenya is sinking, let me tell you, it's not going to sink with only President William Ruto. It's going to sink with all of us. So that's why it is upon us, everybody, to participate in either way. Give your critic, that is building, give your congratulation where it due, it is okay. Disagree with any leader, that's what builds. And that is all Kenya is all about, because that is how our fabric of Kenya was made and created. And once again, thank you so much, Leo Nyabaya. I thank you for joining. It has been long. Maybe your last remark to our viewers.
Thank you so much, Brother Ben and Makubura. Of course, I do enjoy the discussion, and I like the fact that you bring people from different places. The real people on the ground have been following, and for example, your last time when you visited the country, you really managed to engage. I saw some guys that used to engage them in the bunge now, 19 Kisumu. Manyata used to have a bunge with there. He's a good friend. So that is really great. We are reaching our people and we are trying to enlighten them. It's really good if you can have this kind of platform so that you can be able to give opportunity that people don't get in the mainstream media. In the mainstream media, some people have got some good ideas, but they cannot be able to reach there. And with the growing internet and the online platforms, I can tell you that most people get information from this kind of forums before they even go to the mainstream media, and they trust what we give here because they are not doctored. It is direct the way it is. And for my fellow Kenyans, what I can say is that Kenya belongs to all of us. We might differ in ideas, but when it comes to Kenya, then we need to stand as Kenyans. And in regards to right now, as Kenyans, we are having a contest that is next year at the AUC. So it saddens me when I hear fellow Kenyans saying that they are standing with a Djibouti candidate, somebody whom they don't even know. So that one is how low we can go as far as patriotism is concerned. So however much we're having differences, let us not carry our local politics and take it international there. When you go outside the country, Ben will tell you that they treat you as Kenyans. And at some point, I remember I was in Malaysia, and I just met a random black person. I really feel nice only to realize that this person was from Tanzania. And what made me even to spend, I didn't even go back to my hotel. The person could speak Swahili. So it feels good when you're outside there and you meet somebody not only from Kenya but from Africa. So I feel bad when the fellow Kenyans are saying that we're standing with Djibouti when we have our own candidate. So a good night and good morning, everybody. Let us subscribe to the channel and always visit and get updated. And then you forgot to tell them, I also saw you on TikTok. So that those people on TikTok can also be able to get this kind of tips.
Yeah, this discussion also goes on TikTok on Brother Benson Media too. So we are everywhere. We are trying to be in everywhere to spread the message. And Leo, again, thank you so much for joining. I really, really appreciate big time for giving us your time and we don't take it for granted at Brother Benson Media. Bakobura, too, thank you so much for always hosting. And we thank you so much to our viewers again. We cannot go without saying a word of thank you to you because it's because of you that we are here. We've seen you growing together with us. We still continue to thank you. And if you're not a member, kindly go to the subscription and subscribe. It's for free and let us engage. Thank you so much and may God bless you. I'll see you next time.